Right, so let's get back to today. I thought we'd have a look at divorce, which is what I guess most people think of when they have family law. They sort of think, oh, you're a divorce. And we'll have a look at money. I suspect those two topics are natural stomping ground for you and not so natural stomping ground for you. Okay. Don't be frightened of it, is what I would say. There is a tendency for people when they start to think about ancillary relief, which is what we call money, basically, to throw up their hands in horror and think, oh my God. And that's because, unlike other areas of law, our approach to money is very discretionary. And we don't have one answer to a problem. You can have 100 different answers to the same set of facts and they'll all be right. Okay. And some people, particularly lawyers and perhaps particularly commercial lawyers, struggle with that concept of there being no wrong answer and no right answer. So don't panic. When it comes to looking at money, the easiest way to approach it is to start by asking yourself what powers the court has in this scenario. What orders can the court make is the first step. Then what principles apply to that, to the way that the court can exercise those powers, and then, okay, from a common sense point of view, how do we apply it to this particular set of facts? Because the other problem when we study money as an academic subject, or as a practical subject really, is that no two cases are the same. So although we have quite a big body of case law, mostly English, because English law seems to be what Guernsey applies largely when it's looking at the principles of dividing up dosh. Each case is fact specific. So all we can draw out of these big cases that we look at are the principles that the court applies. What we can't do is to identify too much with particular facts of a case, because every case by definition is unique, every family is unique. It's one of the great things. So don't be scared by the fact that there is no definite answer. Just follow that progression, and it means you will reach an answer that is not wrong, which is great if you're a practitioner, because actually it's quite hard to be wrong. It's about achieving the best position that you can for your client in a way that is fair. Because the other issue that commercial lawyers sometimes struggle with is that doing the best deal in a family case, achieving the best settlement in a family case, isn't always about running your position into the ground. Because if someone comes out feeling they are the winner and does better than they should, the reality is that the settlement will almost certainly collapse at some point in the future, and it will have repercussions for the family probably for the rest of their lives. So it's about achieving a deal that works actually for the family as a whole. So don't be scared of it. If we have time, we'll have a look at domestic violence. If we don't have time, we'll leave it till next time, because domestic violence is quite important. And I'm going to assume it's quite important for Guernsey because it's actually got a really high profile in your law, which is quite unusual. And I've found quite a lot of stuff online about Guernsey wanting to be quite careful in its approach to domestic violence. Now, whether that's because you think you have a particular problem in that area, I don't know. But your law in terms of domestic violence is pretty advanced.
What do you mean,
I found subcommittee discussions and things like that within the States about approaches to domestic violence. You've got a lot of help resources for people who are experiencing domestic violence, which is why actually one thing I did in the study guide was to try and set those out. So you know, if you get a client who walks in with a problem, the people that they can actually have a chat with. There's quite a lot of support here. I think that's great. It is far more advanced than Jersey. We have no specific law which relates to domestic violence at all. You're more akin to England in terms of the domestic violence legislation that you've got, which would suggest to me that Guernsey recognises it for the problem that it is. And it is a massive problem. Not just domestic violence, but domestic abuse. In England, we're getting starting to see cases on something called coercive control, which is where someone subtly, but over a long period of time, exerts the kind of psychological influence, almost invariably over a wife, to a point where the wife will black and white swear that their husband is the best thing since sliced bread, and they will believe it. They will lie to you about how wonderful their husband is. They will defend him to the hilt from all attackers. And those cases are particularly difficult. They've just hit the criminal sphere in England. They've had a couple of prosecutions based on coercive control, or where it's been a feature. We're waiting to see really how that feeds through into family law, because there are cases where your client will tell you you're wrong, that their husband is amazing, that they asked for the abuse, that they will not cooperate. So that's a growing area, and one that psychologists are very interested in, the effects of coercive control. One example of it is there was a murder trial, attempted murder trial, a couple of years ago in England, of a husband that was trying to rid himself of his wife who'd just given birth to their child, and he cut the strings on her parachute.
Oh, yes.
And by some miracle, she survived. By some miracle. She wouldn't support the prosecution. She retracted her original statement to the police, told the police that she had lied, and she will still not accept that he tried to kill her, even though it was absolutely obvious he had. And she isn't having it even now. Has stopped giving press interviews. All very strange. So it's looking at why it is that women end up in that position and what the effects on it of that are, might be on money, and might be on family cases. So domestic abuse is a big issue in the UK, lots of learning. Partly because of money, it will come across your desk. Even more importantly for children, which is why if we don't get to it today, there's no harm in looking at it as part of looking at children, because domestic abuse in cases where there are children always features. It's always an issue, it's always a problem. And for a practitioner, really difficult to deal with, actually, in a way that doesn't do more harm than good. So yeah, all good stuff. Right, divorce. When I first got this gig, if I can put it that way, I had a look at the handwritten notes and various other things that were lying around from previous students, and I had a look at past papers, or one past paper specifically, and I thought, there is room for a little bit of confusion about how many grounds for divorce there are in Guernsey. There is one. There is only one ground for divorce in Guernsey. And I saw repeated reference to grounds for divorce, and these are the grounds for divorce. And no, there's one ground of divorce in Guernsey. Okay. And in that respect, you are different from Jersey, and you are identical pretty much to the UK. So for your purposes, you can quite usefully have a look at English law, because your ground of divorce is the same. Important not to get confused, because that is a very easy way to fail exams, is to say, oh, there's lots of grounds for divorce in Guernsey. There isn't. And that is the irretrievable breakdown of marriage. Divorce can only be granted by the Royal Court, and the process is governed exclusively by the Matrimonial Causes Law of 1939, and specifically Part 2 of that law. Okay, nobody but the Royal Court can divorce you. You can't bring proceedings in the Magistrates' Court or anywhere else. We've already talked about jurisdiction, which is inevitably the first thing you think about when you're looking to bring proceedings. Has the court got jurisdiction in Guernsey to do that? We've also talked about nullity, and it's common sense, isn't it? If you want to get a divorce, you first have to be validly married, which is why actually all practitioners should think, when they start to think about divorce, am I sure I've got a valid marriage here? First thing I have to ask for is a marriage certificate if someone mentions divorce, because every now and again you get strange things on marriage certificates, and then you think, again, common sense really. One of you is going to be the petitioner and one of you is going to be the respondent. Okay. That might be different if no fault divorce ever comes in, because it does imply that there is someone who Is bringing the case and someone who is defending it. I suppose it implies a litigious form of divorce. Is there a difference? Your clients will often ask you, does it matter if I am the petitioner or the respondent? The short answer to that is, it doesn't really matter from a financial point of view, because the court can give you the same money whether you're a petitioner or a respondent, basically. Procedurally, it can make a bit of a difference, because the person who is the petitioner tends to be a little bit on the front foot procedurally. It's the petitioner who applies for decree absolute, and they tend just to feel a little bit on the front foot. That's a tactical issue, may or may not be important to your client. Sometimes it's incredibly important from an emotional point of view for one of them to feel they are the petitioner and are in control. So it is worth thinking about it. Don't underestimate the importance of it to your client. Feeling on the front foot is incredibly important to other clients. You don't have to have been married for a certain period of time before you can bring proceedings. As a combination of factors, Guernsey is actually a good place to get divorced, in the sense that access to your system is more open than it is in a lot of jurisdictions. It's not that hard to find that the court has jurisdiction here, not really. And you don't have to have been married for a certain period of time. So one ground for divorce in Guernsey, the irretrievable breakdown of the marriage, and that's Article 60. Irretrievable broken down. But that is not of itself enough to get divorced. It's not enough to be able to say, oh, my marriage is irretrievably broken down. And you'll remember that we had a chat yesterday about the case of Mrs. Owens. The court was quite clear. Timmy Owens' marriage had broken down irretrievably, but she still didn't get a divorce. And that's where the nonsense of the law really comes out. And one of the reasons that is driving law reform in the UK isn't so much the morality of what's fair and what's good and what's just and what isn't. It's the fact that the law at the moment is a bit of a nonsense. It's daft. Judges are playing with the law to try and make it fit a given set of facts. It's become a bit of a nonsense, because in reality it is very easy to get divorced unless one of you doesn't want to. That's the reality of life. And the law has become an artificial construct. You've got marriages where they have irretrievably broken down and everyone agrees that, but they still can't get divorced, even though that's the one ground for divorce that you have. And it's quite interesting if you wanted to know a bit about where this comes from, and I don't necessarily think you'd be examined on it in this course, but it is useful to understand it if you're looking at reform, is to have a read in a book like Herring, or something like that, about where English divorce law comes from. The divorce law, which your divorce law basically mirrors English divorce law, and where it came from in England was a compromise, because back in the midst of time, I think it was in the 1960s, people began to be worried that it was too hard to get divorced, that blaming one person for the demise of a marriage was bad for the family, that it caused problems with children and the upbringing of children, that it was embarrassing. And people started to say, well, hang on a minute, perhaps we should have a system whereby there is less blame, people are encouraged to reconcile where possible, but where they can't, divorce can be a dignified process. And that's what people started to say. And it was the church, the Archbishop of Canterbury, I think it was at the time, produced a paper called Putting Asunder, which was a work on how you could amend or revise the law of divorce in England to try to make it more humane, but also not to make it too popular, because they didn't want too many people getting divorced when they shouldn't. That led to law reform, which led to a sort of compromise, which on the face of it looked like it was introducing a no-fault divorce, because we're just saying your marriage has to irretrievably have broken down, which doesn't necessarily imply fault. Your ground of divorce does not imply fault. But sitting underneath that, we will say, in order to show that your marriage is irretrievably broken down, to prove it, because it's a subjective concept, and we're courts, we like to have nice objective rules. We're going to say that to prove that irretrievable breakdown of marriage, you have to show one of 5 facts. There's the facts of divorce. And those are largely fault-based. So it was always a little bit of a legal fiction, because actually, arguably, that irretrievable breakdown of marriage, which is your only ground of divorce, doesn't really mean very much, because you still have to show one of those facts of divorce in order to be able to proceed.
What was the paper called?
Putting asunder. Yeah, I can say if you're interested in it, and it will never come up in your practice, it will be completely useless to those practicing law, but it is all very interesting. I can send you some stuff on that if you're interested. I think if you're involved in the reform discussions, which some of you guys will be, and I know that there are discussions ongoing in Guernsey about it, there's a massive consultation happening in England, by the way. If you have a look at the gov.uk site, they're out to consultation on their divorce reform at the moment, and there is a government paper on it, which is really useful in talking about where the law has come from and the problems that they see with it. And that's off the back of the Owens case. Yeah. So gov.uk has some amazing resources on it for family law. Really is quite useful if you've got the time and the energy and the interest. It doesn't help you do your job, but it is really interesting. But if you're looking at law reform, it is really useful to look at where you've been and how you've got where you are, and to look at why reforms that have been tried in the past, notably the one in 1996 in England, fell flat on their face, very expensive, and didn't work. And it's partly because there is a large sector, ignoring what lawyers think, because we like to think we rule the universe, actually we don't. The law should reflect the society it's designed to serve, but the other way around, in theory. Ignoring what lawyers think, there is a significant part of the population which still believes that divorce should be fault-based, and that actually you should only be able to get out of it if you've got bloody good reason. And that is still a widely held popular belief out there. So it is questionable the extent to which the idea of no-fault divorce is being driven by courts and lawyers, or actually driven by the people that the law is there to serve. Because a lot of people will say, I had one client who put it to me very effectively when we were talking about what they are grounds of divorce in Jersey, but what basis of divorce she should use, adultery, or we were approaching separation ground. And she said, you know what, my marriage didn't die, it was murdered. And I want my divorce to reflect that fact. And it's very difficult to argue with someone who feels that way, actually. Because, we still do, in theory, marry for life. So it's a very emotive issue. Technically, what it has given rise to is something that is a bit of a nonsense, because like lots of areas of family law, it tries to keep everybody happy. Okay, and a lot of areas of family law are effectively a fudge. Okay, and this is a galactic fudge. It's playing lip service to the idea of irretrievable breakdown of marriage, which is a no-fault-based concept. It's a let's look to the future, guys, kind of an idea, but it returns those 5 facts of divorce. The reality of it is that the vast majority of divorces, and I'm sure Guernsey is the same, go through on the nod. It's you're different because you actually require a court hearing, but in England and in Jersey, you fill in bits of paper and that's it. And you literally tick a form to say you're giving your consent, sign it, or you just don't defend the proceedings. I don't think we've had a defended divorce in Jersey, certainly since I've been practicing, so 20, 25 years. There isn't one within practicing memory that I'm aware of actually going to trial. Are you aware of any defended divorces in Guernsey? I couldn't find a law report. And they're held in open court, defended divorces. Which I think your clients to remember, if they want to be really contentious in the grounds they're using or the facts they're using. that, as far as I can tell, they're in open court. They certainly would be in Jersey and in England. Reported cases. I couldn't find one in Guernsey, which would suggest to me that there haven't been any, at least for a very long time.
So never someone saying, no, I haven't crossed it.
What
co-respondent?
co-respondents hardly ever reply unless it's to say they don't want to pay the costs. A lot of the time they ignore the papers.
Maybe half the time not going to be in Guernsey.
Yeah, so some of them are married to other people,
Yeah.
and would rather not draw attention to them, and they don't want to lie, and they're not required. Nothing nasty happens to them if they don't fill it in, except possibly a cost.
So would the correspondent ever have a cost order?
Oh yes, all the time. If you go for adultery, yeah.
Yes.
They will pay. One of the problems with having fault-based divorce is that if it goes through on the petition, there will be a cost order.
So the chap who's having the affair with the married woman, they cost. No.
Yeah, regularly. Yeah, you'll always ask for costs against the correspondent, and if they're the ones with money, they'll be the one that pay the bill. Yeah. Absolutely.
And the correspondent can do what to test?
They can try and deny the adultery, or they can just come back and say they're contesting the costs, in which case they may have to come to a court hearing to argue about it. But costs, certainly in Jersey, nearly always, if not always, follow the event of the divorce. So if there has been, if the petition goes through, other than based on separation by consent, they will generally get an order for costs. Because it's fault-based.
Is that the same in England?
I suspect there are so few defended cases in the UK. I doubt it comes up very much. In adultery, in England, you don't name the correspondent. That is a Channel Island thing.
Oh, I see.
Well, they wouldn't be a party. But here and in Jersey, they are a named party, which is why most lawyers in Jersey, I don't know if it's the same in Guernsey, but most lawyers in Jersey try and nudge their clients against using adultery because it's so inflammatory, because you have to name and serve the correspondent, and there's always a risk they'll turn around and say, oh, absolutely not, wouldn't go near the bloke, or whatever, which can make it difficult to get your divorce.
The ones that I've seen with adultery, the correspondent has been quite happy to have their name.
Yeah, sometimes it's an openly, quite often they're in an open, everyone knows about it relationship anyway.
I think that if your relationship is broken down and you move on with somebody else, they're going to be like,
yeah, I mean, and I guess that's because in modern days, that's often what adultery looks like. Back in 1939 or whatever, it was probably much more subversive than that. It probably was a secretive thing that was happening behind closed doors. The only time I've seen it cause a real issue is where they've been married to someone else and their spouse has not known about the affair. And I've seen one or two of those they've tried to defend.
and some petitioners might want that question the respondent through that.
Oh, they love it. Yeah, absolutely.
Sort of get their moment.
Yeah, they love it.
You've done it.
They love it. Although they tend to, as soon as you tell them it won't make a difference financially, they tend to be less bothered in my experience.
So I have a question. Let's say that two married people have separated.
Yeah.
And this is a question that actually was asked of me by somebody else kind of knew. I would say his friend. He separated with his wife. But found somebody else who asked me what adultery meant. I did a quick look. I think what actually it means, to, as we've discussed yesterday.
Yeah. Sexual intercourse between people of the opposite sex during marriage.
Yeah.
To someone else.
He said, well, if you don't actually do anything else. And I said, well, I've got no
That's
idea.
not adultery.
But I said, it doesn't look like it, but surely it would be unreasonable.
Yeah, it would be behaviour. Yeah, it probably would be behaviour. And
in that case,
there would be no correspondence.
Okay.
And one of a question a horrible examiner might ask you, and I have seen them exam questions, is Mr. So-and-so has had an affair with Miss So-and-so. Mr. So-and-so's wife wishes to divorce him on the basis of his adultery. Can he do so? Be very careful about what the word affair means and what the test is actually for adultery, because it is sexual intercourse, no more, no less. And one of the useful things about being able to use behaviour to a degree is that you don't have to be sure that there has been actual sexual intercourse. Sometimes you use behaviour because you know there's been an inappropriate relationship, but you don't know, and they haven't admitted actual sexual intercourse. Sexting is a classic example.
In the petition, it used to say on or around a date that you believe that the intercourse has happened. Or if they said, you know what, I went away last weekend, that has to be in the petition for adultery.
If you know it, or you might be saying, he has admitted to me that at times and places unknown, he had sexual intercourse with other women. Yeah, their identity was not known to him occasionally, and you have to actually ask for permission not to name them in the divorce petition. Prostitutes is a problem, which I've come across in the past. And you also have to say whether the adultery is ongoing or not, normally.
You wouldn't always know that.
You wouldn't always know it, and you can only say what you know, at the end of the day.
But you have to put that in the petition.
I normally do, whether you believe it's ongoing or not. I've not done an adultery petition actually for ages. As I say, as soon as I tell them it's not going to make a difference to the money, they tend to not be that bothered. And it increases the cost because you have to serve 2 parties. So it's much easier not to bother with adultery. Right, so what are your facts to prove the breakdown of marriage? Article 16A. And the problem that we've had with cases like Owen's arises out of the wording really of this article, which is the same in the UK basically. The court shall not hold the marriage to have broken down irretrievably unless one of the 5 facts is shown. So the court cannot find that you have your marriage is irretrievably broken down, even if it does find that your marriage is irretrievably broken down. For the purposes of divorce, it can't make that that decision unless you can establish at least one of these 5 facts.
When would the situation occur that you use more than one?
I have pleaded them in the alternative. I have, particularly where I think there is a risk that it might be defended, because of course you only have to get them to admit one. And quite often it's a combination of more than one, so you may well get adultery, but also there's been other aspects of behaviour that are not reasonable.
And if you don't have agreed particulars, then you wouldn't know.
Then you wouldn't know. So at least that way, they only have to be able to admit enough to be able to not contest the divorce.
So you can plead more than one
Yeah,
marriage.
you can. And I sometimes do it with more than one. You only need to come home with one.
Because they might defend.
They might defend adultery,
Will on behaviour grounds.
but it may be they can't deny the fact that they sent sex messages to people because they know you've seen them. Plus, it has happened quite a few times actually. They send them to the wrong person. They accidentally send sex messages to their wife.
And then their wife is thinking, what's going on here?
Well, and it happens all the time because they just send it to the wrong person. It's modern technology. How often do you send an email to the wrong person by accident and think, if it's your wife? It happens in these cases as well, where wives get messages and they think, he hasn't talked to me like that for a long time. And then they find an opportunity classically to go through their phone, which they shouldn't if they ever ask you. That's definitely a data protection offence to go through someone's phone. It's not your data, it's not your information. They must not do that. But they've normally done it before they can see.
Take a picture of somebody else's phone.
Oh, yeah, all the time.
They do what, sorry? Take a picture on their phone of the messages on him.
Very naughty. Very naughty stuff.
Never advise that.
The husband and wife typically will share things. So you might use the, and yet he is deleting, saying to his lover, I don't text after this time, and deletes it, and puts him in his name as John or Bob or something.
I've never actually come across couples who routinely share phones. I've come across couples where it's a bone of contention that the other party insists on looking at their phone. And I've even had people use that as behaviour itself, the fact that their spouse insists on keeping tabs on their phone.
There's a lack of trust.
Because that implies a lack of trust and control, actually. That's verging on emotional abuse, I would say. To insist on.
And sending
I refuse to even answer my husband's phone. Drives him nuts. It's
I
really.
don't like that.
Actually, it's not mine.
sending messages, sending inappropriate or sexy messages to somebody else, that would
I think that's behaviour. If my husband sent a message to another lady saying, I want to do X, Y, and Z to you at the weekend, you're gorgeous, I love you, kiss, kiss, I'd say that was behaviour that was unreasonable.
and that would be a ground for.
You could use it as as evidence of a fact.
Very interesting.
Sorry,
Yeah, yeah,
would
just
be one
be careful
ground
of using that
for-
word ground.
Yeah.
Think it was a
Thank you
fact.
for picking up.
And it's such an easy mistake to make. And actually, that's a perfect illustration of how stupid the law is. Because of course they are the grounds for divorce. Of course they are. Because without one of them, we can't have a divorce. So it's a bit of a nonsense, but strictly speaking.
I don't know if you I saw there was an article in the news this morning about a ruling of the court in Kent, and it was in domestic abuse proceedings, but the respondent, who was the husband, said to the court that she can't have actually been afraid of me or under any real threat, because on her text messages to me, she still put XX kisses, and the judge ruled that text is not an indication of flirtation, it is a sign off to a message. Which I thought was really interesting, because I don't know if
I think it's interesting. It's probably not a conclusion I would have come to. I think it's probably a conclusion the judge wanted to come to, because he didn't want to say that this woman, because it is, again, a feature of domestic abuse that people will do that. They're very affectionate.
Well, is it because the control is inherent in domestic abuse?
Yeah. It's an expectation that, the other half isn't necessarily doing anything wrong, or a desire for their affection. Having said that, I don't think it would be appealable, because I get a lot of messages from female friends which stand up for kisses. Or the kind of thing. Yeah. What's the boy put kisses at the end of their text messages? But it seems to be a thing. So, but yeah, domestic abuse is really interesting psychologically, and a lot of the behaviour petitions I draft now are basically on the basis of some form of domestic abuse of some kind. Most of them are, and that's because it becomes psychologically important for the lady often to draw a line under the marriage so the man knows it's over. So they're issuing before the separation period comes up. Even where we're dealing with money, it becomes important to deal with divorce.
How would you deal with solely emotional abuse? Because I'm envisioning a situation where sometimes that's actually very difficult so they go to the step where they say, I know this is wrong, then they get this sort of yo-yo of, but
I think one of the problems with domestic abuse is it's quite, people make an assumption it's all one way. Domestic abuse relationships are really strange. There is a really strange dynamic, and that is a two-way thing. Quite often you will get a woman saying that a man has been domestically abusive or violent, and this is what is done. A husband's stock response to that is, she's nuts. She's made all kinds of allegations that are completely untrue. She's a danger to everyone around her. She drove me to distraction. Everything I did was what any normal person would do in these circumstances. And they quite often are very plausible, very reasonable appearing people. And quite often you will have some very stupid actions on the part of the victim of domestic abuse, where you'll be looking at it thinking, it actually makes it quite hard for me to show that you were scared of this person, because sometimes they can appear quite aggressive in their response to their abuser. Sometimes the abuser can seem almost subordinate to them. They do sometimes tell porkies, victims of domestic abuse, particularly in defence of their husbands. They'll tell people anything, including important people like the Children's Service and the police. They will lie. So all of that can come back to bite you. So they're never easy running domestic abuse cases, ever. Domestic abuse victims are difficult to work with. So are abusers, but they're equally probably difficult to work with for different reasons. So yes, you can plead emotional harm, distress. It's harder to prove, like everything. But then even with domestic violence, it's very difficult to prove because they very rarely go to the doctor unless they are harmed to a point where someone else calls them. Occasionally you have records of police calls out and call-outs, but very often not. So there often isn't any objective evidence of domestic abuse at all. So what you tend to end up doing is breaking it down to the husband does not allow the wife access to the joint account. The husband does not allow the wife access to X, Y, and Z. The wife does not. The husband takes the wife's SIM card out of her phone and retains it. Things like that. So facts which are objectively provable, which add up to, you know, emotional domestic abuse. Partly a problem because most abusers will look at what you've written down and say, yeah, well, it's not abusive. And that's one of the great problems of domestic abuse. They do not think that what they're doing is abusive behaviour. And there are some judges out there who might even agree with them. That's the other problem. Judges set that bar in very different places when it comes to domestic abuse, in my experience. I've had some jaw-dropping remarks from judges, and I was quite sensitive to it. You know, it ranges from, well, he didn't hit her very hard, did he? to you know, quite careful consideration of emotional abuse. So, you know, it's also to do with societal attitudes and stuff like that, but they are really difficult cases. So you've got your 5 facts. First one, do remember that with adultery there are 2 limbs to it, which people forget about. Has to be a commission of adultery, which is sexual intercourse with a member of the opposite sex. And you have to find it intolerable to live with the respondent. But because the law in this area is an ass, there is no connection between the two. You don't have to find it intolerable to live with them because of their adultery. The two are not linked. But they are ingredients of the same fact of divorce. Okay, and adultery is actual sexual intercourse. Respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with them. That's B. So that requires 2 things. It requires behaviour, and that behaviour must be outside the normal rub of married life. You're looking for something that gives you justification to walk away from the marriage, essentially. And in such a way that the petitioner can't reasonably be expected to live with the respondent. At that stage, the court is looking at this petitioner and this respondent. So it's a mixture of an objective and subjective test. Objectively, there has to be behaviour, so there have to be actual facts of behaviour, actual incidents that you can plead. And then the court says, could this respondent, this petitioner, be expected to live with this respondent? That has led to some really weird divorces, as we'll see in a minute, and that's the basis that Tilly Owens tried to use to divorce her husband. Desertion of at least 2 years before the petition is presented, very rarely used. I would say probably never used in Guernsey anymore. I'd be surprised if you ever used it, but it's still in theory examinable because it's still there. It is a way of trying to bring a divorce based on a 2-year separation where there's not consent. Then there are the consensual or the no fault sort of elements, if I can call them that. Living apart for at least 2 years where there is consent, and living apart for 5 years where there is no consent, but there might be a defence to that process of divorce. Now, there is case law around each of those facts, which tells us a bit about them. And when you look at the case law around each of those facts, the law in a way becomes even more of a bit of a nonsense. And so it's a great relief that most divorces are not contested. What tends to happen is that even if they're defended for a little bit, eventually people come to a separation ground which they accept and then move on. You very rarely end up in final hearings. Tilly Owens being the exception to that. You are, I wouldn't say required, but it is good practice when your client consults you about a divorce to think about what facts you are using and to think about what the impact is going to be on the family, on the ability to have a non-contentious divorce process if you can, on costs. So actually holistically, if I can use that word, which I hate, what is in the best interest of your client in terms of what facts you are using as a basis for your divorce, for their divorce, and what the effect is going to be, because you have more experience than they do. Chances are they've never done this before, they don't know what's coming next, whereas us guys are meant to know. So think about how you're going to guide them down that route. Now, Guernsey law encourages reconciliation. And the way that it deliberately encourages reconciliation that's relevant to divorce is to give wiggle room around each of those 5 facts for you to explore reconciliation without losing the ability to bring your divorce. That's great. The reason it is there, it's great from the point of view that the reason it is there is to encourage reconciliation, which is one of the stated aims of the law, and these similar provisions exist in England. Perhaps not quite with the same emphasis, but they're there in the UK as well. We want to encourage reconciliation, give people breathing space to make sure they're sure that this is what they want before they actually have to pull the plug and start. And we don't want them to suffer the consequence of being trapped in a marriage for having explored reconciliation. Okay. These reconciliation provisions exist in England, don't exist in Jersey. From a legal perspective, they make the law a little bit more complicated and a little bit more of a nonsense in some ways, because you've got a fact of divorce, for example, which says respondents committed adultery, petitioner finds it tolerable to live with the respondent, but they might want to live with them for a bit before they have to decide whether it's tolerable. Even the separation facts enable you to live together for a little bit without losing the ability to use those separation grounds. It's all a little bit strange, and the same with behaviour. Even though it's not reasonable to expect you to live with them, you can live with them for a bit just to make sure it's not reasonable for you to live with them. So they never seem to me to be particularly logical, but they are there to help reconciliation. So from the point of view of advising clients and exams, you need to know stuff about the fact, so the case law around the fact of divorce, and also the wiggle room around reconciliation, because what will happen quite often is you'll get a client in who will say, I found out 3 months ago that my husband was having an affair. He admitted it to me. We've given it a go, but I just cannot get my head around it. I cannot do this. I need to get divorced now. That's really, really common, because with adultery in particular, if it's a very sudden and surprise thing for the offended party, for the petitioner, prospective petitioner, they will not necessarily want to pull the plug immediately. They'll want to look at whether they think the marriage can be saved. So it is a practical issue you need to be able to advise them. Talk on page 37 about what we mean by adultery. Case of Cleary, which says that those two things aren't linked. And Article 10, which says that you have to join your correspondence unless the court decides otherwise on special grounds. Don't know what special grounds are. Couldn't find anything on that, but. And then you've got a provision which enables them to think about reconciliation. That's in Article 9. The reconciliation provisions are basically in Article 9. When spouses have lived together, after it becomes known that one of them has committed adultery, if that period is 6 months or less, you can disregard it when trying to prove that it was intolerable for them to live together. The reason I find that odd is because it does suggest a link between the adultery and the intolerability, but okay, whatever. None of it's logical anymore. I've lost the to find something logical. But you can't remand the adultery if you live with them for more than 6 months. So, and again, classic problem question area in exams, or when clients come and see you, if they say, my husband had an affair a year ago, we've done our best, we've had the counselling, I can't do this anymore, she's not going to be able to rely on that adultery that was a year ago. It might be behaviour. You might get away with it under behaviour.
What classifying it as an inappropriate behaviour?
As part of the background, because what you would say, classically I've had in petitions, husband had an affair a year ago, parties attempted counselling, husband kibosh counselling, has threatened to resume relationship, is doing X, Y, and Z. So there tends to be a continuation of some kind of behaviour that enables you to use it as the background, but you can't use that adultery if it's more than 6 months old. Is a tricky one. Behaviour is Article 16(1)(b). It's not unreasonable behaviour. It was, I haven't looked, I'm not sure if there are up-to-date statistics, but in England it was the most common fact use for divorce behaviour. Because it's quick. It does not require you to have been separated for years and years. And they tend not to be defended. So again, there are two elements to that, just like adultery, the behaviour and the unreasonable expectation of cohabitation. Petitioners prove their case. Can be acts, omissions, or a course of conduct. And behaviour can occur following the separation. That is quite useful because sometimes what you find is that the behaviour which makes it necessary to press on with the divorce may be stuff that's happened since they physically separated and not before. For example, I've got one case at the moment where the separation triggered really abusive behaviour by the husband against the wife, some really quite vile stuff, and that's been pleaded in the divorce petition. So it's quite useful to know that. Lots of people, lots of courts have tried to define behaviour. It's another one of those things that isn't defined in the law quite deliberately because it would be impossible to draw up a definition of the kinds of human behaviour that could pass this test. But it has to be outside the normal rub of married life. One of the arguments in favour of reform, and the Law Commission have been saying this for quite some time, is look, if you've been married for any length of time, you will have this fact of divorce because humans, being humans, we're all capable of doing stupid things. And people can use in petitions some really innocuous stuff. Didn't walk the dog, I've seen. Leaving the top off the toothpaste is a stereotype which does get used. All kinds of things. Now, historically, that has been enough to get you through the court if it's not defended. Whether that will change following the case of Owens probably depends on individual judicial attitudes in different jurisdictions. We've seen a change in Jersey whether you win in Guernsey, I don't know. It may become harder, it may not. But at the end of the day, if it's undefended, it comes down to the judge. Looking at whether they can live together is subjective and objective. We look at the particular spouses with their particular attributes and characters, and then we look at objectively whether they could be expected to live together. And the classic observation is in Livingston Stallard, English case. Would any right-thinking person, whatever that means these days, conclude that this husband has behaved in such a way that his wife can't be reasonably expected to live with him, taking into account the circumstances and the characters and personalities of the parties?
What has he done?
I don't know what he'd done in that case. Again, the facts are not as important as the principle, because the facts are so diverse in divorce petitions, apart from being hilariously funny, some of them. Hilariously funny to read, not if you were involved in them, I suspect. And one of the interesting things to think about in terms of divorce reform is what the impact is of having to go through this in terms of embarrassment and pain. Okay, so what's commonly pleaded? Violence, abuse, inappropriate relationships. Drinking is a very common one. Overworking, we see quite a lot in Jersey. He is always at work. He works 12 hours a day, 7 days a week. My husband threatens to divorce me on that basis regularly. We see that quite a lot. Misappropriation of money. He spent our joint account on a Lexus. Fun stuff. All kinds of things. Gambling. Gambling's a big one. Okay. You can't rely on desertion for the behaviour ground. The general rule is if you should be pleading under another basis, sorry, I shouldn't use the word ground there, I should say that. It's particularly confusing for me because we have grounds in Jersey and not. Okay, so this is on page 39. The general rule is that if your case falls under one fact, don't try and plead under another one just because it's easy. Okay, so desertion is quite hard to prove for various reasons, but if it's a desertion case, you should plead under desertion. Sexual behaviour or sexual behaviour with a same-sex partner may well be behaviour. That's the Watchdog case, which is quite well known. You can still be living together when you bring your behaviour petition. And this is a case, one thing to be slightly careful of, I suppose, all the divorce cases in England really, apart from Owen's, go back to the 1970s. And you will see facts cited which just would not happen now. For example, the case of Bradley, if the Children's Service let this go, then there'd be probably a national outcry. But back in 1972, seriously, the issue was whether the wife could bring a petition after her husband had attacked her and one of the children, there were numerous children, with a knife, but she'd remained in the house because she had nowhere else to go, and the issue was whether she could still bring a divorce petition. Now, I don't think that would happen today, partly because he would have been removed from the house. Well, in the UK in 1973, it was a different world, I guess. And people were probably saying, well, you know, they tried to stay together for the sake of the children. It was useful to have him at home. He was only a bit stabby, you know, only a little bit stabby. So, but I always read that case and think, oh my God, but it was 1973. And there are some really, really funny cases. And they're all sort of the 1960s, 1970s. Fascinating time to be alive. Case of O'Neill, where a DIY enthusiast took the toilet door off and took 8 months to replace it, which seems amusing, but what's the first thing you might think of if a wife came to you with that scenario now? Yes, it's a flag for domestic abuse, because it would tend to suggest you've got a husband who is effectively carrying out surveillance on the wife. Wow. You would have to wonder if they're removing doors on private places, like bathrooms, not allowing them privacy. I had one case where the husband insisted, even though he'd moved out of the matrimonial bedroom into another bedroom in the house, that bedroom had, the matrimonial bedroom had an ensuite. He insisted on using the ensuite bathroom in the wife's bedroom, even though he had his own, as a means of denying privacy. and he would walk into the room in the middle of the night, wake her up, go and use the bathroom, and go back to his own room. It was a form of control behaviour. So although on the face of it, you've got a husband who's really bad at DIY, and believe me, there are people out there who will start projects and then abandon them, you'd have to wonder whether there was something more sinister going on. And you probably ask that question now. What else is going on in your house?
Well, is he controlling the plans because she hasn't got somebody else in?
It would make you ask questions about what was going on. You'd ask wider questions about what was going on at home. Because, you know, you just would, you'd want to know a little bit more about what else was happening. Lines and lines, again, husband wanted the wife to tickle his feet. He had a thing about that for hours and hours, left her with uncontrollable hands. It was only reported in the Times. And then if she said no, he would sulk for long periods of time, which is fine. But again, probably these days bordering on abusive behaviour.
That's repressive streaming.
Yeah, it probably was. So, you know, Le Brocq is probably the funniest one. I don't know, it could Channel Island know. I don't know where that originated from. It's an English case. The wife claimed the husband's submissive character and his refusal to argue with her was so infuriating it amounted to behaviour with which it was unreasonable to expect her to. I can't remember if she won that case actually. Too submissive, yeah. Too wouldn't stand up to her, and it was so infuriating that she couldn't survive the marriage.
Breakdown in communication.
Yeah, absolutely. Yeah. Cases around mental health are really difficult. They're probably the hardest behaviour cases I do, in the sense that very often a wife will come or a husband and say, look, these are the dreadful things that have been happening in our house, but they are all due, and I accept they are all due to the mental health of my spouse. So my spouse is bipolar, my spouse suffers from severe depression or whatever, therefore they do X, Y, Z. They shout, they scream, they lock themselves away for days, they are prolific spenders of money, is a feature of some mental illnesses. They do this, that and the other, and I just can't deal with it anymore.
But surely that would satisfy both the objective and subjective tests.
The law is slightly contradictory, actually. I think you are generally okay in pleading those kinds of facts. There is some old case law which says, well, it's not their fault, so you know you can't really blame this behaviour. But I think generally you are okay, provided you're likely to have. You might have a problem if their behaviour is not positive. So if it's they don't get out of bed for days or whatever, it's harder to found a petition on that basis than it is if their behaviour is truly awful. And there's one case where the husband suffered some kind of brain injury and became a paedophile and started abusing their grandchildren. So, I mean, some of this behaviour can be quite extreme, particularly injuries which cause personality change, which are not uncommon with head injuries, that kind of thing. So sensitive pleading is required, but you're probably okay.
Doesn't that engage our mental health law?
You have to be careful. If you're pleading it, you have to be careful of capacity. So you do have to say to yourself, am I content that this respondent has capacity? Particularly if they have been hospitalised. And you'll have to keep an eye on that throughout the case, including when you're talking about money, actually.
How would you get around that you don't have a guardian appointed?
Yeah, there are divorces where you do have to have a guardian appointed.
Just for this issue?
Or, and it can, one of the problems with mental health is that there may be times when they have capacity and times when they don't. And because divorces can span years, I'd say the average divorce start to finish probably about a year in terms of sorting out the money and the kids and everything else. There are likely to be times when they dip in and out of capacity, so you sometimes have to regularly review whether they have capacity for particular things, particularly if you get near final hearings, because quite often the stress of approaching final hearings gives rise to a real concern about capacity. I've had one client who collapsed outside a courtroom after a massive panic attack, and that caused a real problem. So you have to keep a constant eye on it, actually. So it is mental health cases are really tricky.
If you looked for the petitioner one, and her respondent husband is one with bipolar,
Yeah.
to condition which she finds intolerant to. Do you have to ensure that he has a guardian?
Only if you have reason to think that he does not have capacity, and the test for capacity is pretty low. If you're walking around in the outside world, you've probably got capacity.
Okay.
So you're talking about cases where someone really is incapable of managing their affairs, and in those cases you do have to think about whether the person you're about to serve with proceedings has capacity or not. And those are going to be obvious cases where someone's receiving long-term psychiatric care, that kind of stuff, as an inpatient, that kind of stuff. Harder are the cases where, for example, you have to decide whether to plead the fact that the respondent has made a number of suicide attempts. You have to consider what the effect on the respondent is likely to be. Are they going to top themselves? Are they going to do it in front of the kids? Are they going to attack your client? So it's tricky from the point of view of advising. Again, I'm going to use that horrible word holistically on what the outcome of the petition is likely to be. You have to be slightly careful.
Yes, that could come up in domestic abuse, where if you don't do this, I'll do this.
Very commonly, the reason for domestic, or the background to domestic abuse, is mental health. Very common. Domestic abuse doesn't just come from nowhere. It tends to come from damage of some kind. So mental health problems, abuse that the abusers suffered themselves as children, whatever, doesn't tend to just come out of the blue. But it does require very careful management where there's any mental health concern. Your correspondence must be of a particular tone, because I've certainly had cases where I've received unpleasant letters, and you must, in those circumstances, consciously think, do I send this letter to my client, or do I summarise the stuff in it they need to know? I have held back correspondence from my clients if I felt it was going to impact on their mental health. Others I have suggested they read correspondence or pleadings in the company of their key worker, things like that. And if you are on the other end of a client, or rather if the opposing party suffers from mental health problems, be very careful of sending nasty letters. I have had clients who have come very close to suicide because of unpleasant correspondence from the opposing system. And that is a world of pain. Apart from what it can do to the family, the consequences legally are quite profound if someone dies halfway through a divorce, because the court's powers, in terms of the orders it can make, I'm not sure it's clear under Guernsey law what those powers are. But it's very difficult. So be very careful of cases where there are mental health problems. And quite often the first taste of it is when they come to you in relation to their divorce. Thurlow was the case of an epileptic. She got an annulment under Guernsey law. She was an epileptic, but anyway, she had developed a neurological disorder, so she became much worse, was incontinent. She started setting fire to things. The husband had become unwell, taking care of her. And the court allowed that divorce, but did say if the wife had just been a human vegetable, it would have been difficult to use the ground. Now, obviously, in 1976, people used words like human vegetable. It's not something that's right up there with mental defective, probably, in terms of the words that we would use now. But if you have someone who's in a coma, for example, and therefore unable to participate in family life, I'd question whether you could use that as behaviour, because there is no positive act on their part at all, and no fault-based issue. So,
If it went on for long enough, for 2 years, could you argue desertion?
no, because that
Oh,
requires
intention
mens
actually,
rea,
yeah,
essentially.
it does.
So I don't think you could, no. I don't think you could, but I'd question that. Question it, whether you could use it or not. Which is one of the problems of divorce. You can have couples who literally end up in a position where they have no fact of divorce for 5 years. That's a long time. So the system works brilliantly for people who want to get divorced, where they both want to get divorced. It can happen very quickly and quite cleanly, actually. It doesn't work where there's a problem or where there's a dispute. Richard's mental illness case, he struck the wife around the head only 4 or 5 times, woke the child of the marriage up, which actually would strike horror into the heart of most family members now, because you'd immediately think, oh, this is a child who's been harmed. On a second occasion, he slapped her when she declined sex, which was no big deal back in 1972, apparently. Behaviour was due to the mental illness of the husband. She was denied a divorce back in 1972, even though he slapped her because she dared to say she wouldn't have sex, which smacks of
So
marital
that's
rape.
almost using mental health as a defence.
To me, that's a judge of 1972 saying he didn't do anything wrong, did he? He wasn't acting unreasonably. It would not happen now. I can say with a fair degree of confidence, would not happen now. And that's one of the problems with these divorce cases, of their time, as is the divorce law. Case of Owens, and I'll give you the Court of Appeal reference there. I can upload that case to the VLE if you want to read it. Really interesting decision. The Supreme Court is, I found it less useful from an academic point of view. It's perfectly sound, but not quite as in-depth. And I've given you there the quotation from Sir James, which sets out what he thinks the law is, or what the law is, because he's never wrong, as James Bonby. Court has to evaluate what's proved to have happened in the context of the marriage. This wife, this husband, basically quoting from Livingstone Stallard. Court then has to ask itself the following questions. There you go. And that's where you get that phrase from, as I've observed during the course of this argument, Parliament has decreed that it is not a ground for divorce that you find yourself in a wretchedly unhappy marriage, though some people may say it should be. Tricky. Reconciliation in behaviour cases, Article 9, again, where you've lived together for a period of up to 6 months. That can be disregarded. And as a rule of thumb, most lawyers expect if you're going to bring a behaviour petition, your guidance to your client is really we should get on with it and do it within 6 months of the separation, really, particularly if the behaviour is not ongoing. No separation. There's no rule, but Okay, so drafting a behaviour petition is particularly difficult because you have to. It's very tempting, I think, for inexperienced lawyers to be quite gung-ho about behaviour petitions. They chuck in the worst of everything. They tend to give you chapter and verse. You get very long behaviour petitions, and they'll make it as bad as they can possibly be. Be careful of doing that because you have to think about whether it's more likely to be defended, whether there's a good reason for using these facts. Are they going to be important to finances? Are they going to be important to the children? Can I whittle it down to 3 or 4 things that can't be defended objectively, and what is the impact going to be on the people involved and on the children in marriage.
Did you not say before that in behaviour cases, they're pretty random things that not all come to a with toothpaste has been?
In the past it has, and that's, you know, either it'll get past your judge or it won't. You can, on the other hand, get, as I say, it tends to be relatively inexperienced lawyers who throw the book at it, so they will say some really horrible things. You know, the respondent smells, the respondent's personal hygiene is bad, his breath stinks when he tries to kiss the petitioner. You know, things that it's just unnecessary and don't help anyone. So I think it's just being careful not to throw the kitchen sink at it. Every word written in a behaviour petition should be there for a reason. If it's there for a reason, fine. And it should be a carefully thought through petition in the sense of, I have thought about the effect that this is going to have when it is served. I have thought about the likely outcome for my client, and together we are happy this is the best way forwards. And this is what we are doing. Rather than serving a divorce petition where the contents are easily defended, going to be disputed, not necessarily relevant to anything, and just make the other side go, oh my God, because that sets the tone for the entire case if you do that. And it will set the tone for financial negotiations. Because if you make the other party feel offended for no good reason and you are critical of them and you deliberately set out to embarrass them, they're going to be less amenable to being generous. It makes people defensive, and it doesn't help children. So every word that's in a petition should be there for a reason. Desertion is really weird, rarely used anywhere, as far as I'm aware. It requires, again, there are two elements to it. There is a factum and there is a mental element to it. The factum means that they must have been a desertion, must have been without the consent of the petitioner and without good cause. Even so, you can still be separated living under the same roof, which is bananas. It requires mental intention to withdraw permanently from cohabitation throughout the 2-year period. That tends to be the tricky bit, is proving the intention to withdraw permanently. That's called the animus deserendi, the mental element of desertion. And a period of desertion can continue. This goes back to your bloke in a coma, the lady in a coma. That period of desertion could continue during that period of being comatose, provided the intention had been formed already. So it continues to tick along. So you have to be able to show that it would have been a desertion even if they hadn't been in a coma, basically. Karashi, husband, perfectly legally under his own legal system, wanted to marry a second wife. His wife didn't want him to, but he did it anyway. And he then tried to do her for desertion when she left him. And the court said no, the wife had good cause to leave her husband in that case. And again, you've got Article 9, another reconciliation provision. Separation. The difficult thing about separation is understanding the time limits. So it's 2-year separation with consent for 5 years or not. The tricksy bit of it is understanding what we mean by separation, because it's not what most people think we mean. Whether they are living under the same roof or not, they need to be leading completely separate lives.
So, if they live together under the same roof, because there's, one house, they're cooking separately and living separately.
Cooking, shopping, washing.
And then after 14 months, they'll share dinner together tonight. Does that restart the clock?
I think you'd get away with that. What I would do in those circumstances is when I'm setting down my divorce, I would draw to the attention of the court that, because when you set down certainly in Jersey, a separation petition, you are asked what the living arrangements have been. And I would say they have lived entirely separate lives. They have on one occasion had a meal as a family for the sake of the children. That's probably what I would say. My judge would let me get away with that, because it's quite common after you divorce to carry on occasionally having a birthday dinner or whatever. I don't think that's inconsistent with living separately. If you're having a family dinner once a week and quite why they do it is beyond me, but I've had a number of cases where they've gone on holiday together. Why you would want to do that with someone you're separated from is beyond me, but they do. Or they still carry on cooking, cleaning, shopping for each other, that kind of stuff. They're probably not separated. Even catches out people who are not living under the same roof. So people understand the problems of living under the same roof and being separate. That's fine. It's also an issue for people who aren't living under the same roof. You get cases where people not living under the same roof are going to earn holidays together. I've had to tell them, sorry, I think, really we're looking at starting a clock again, to be honest. Or they have had one-off sex, it's quite common, in a moment of weakness. For old time's sake is what they tend to tell you. Yeah, it just happened. It was a way of saying goodbye. No, it wasn't. No, it wasn't. It was a married life. It was a way of not saying goodbye, actually, specifically.
Yeah,
we sort of do
to say goodbye.
Oh, why do they do anything, these people? But that's quite a common one. I've even had one that resulted in pregnancy. Which is unfortunate, but there you go. So yeah, and you sort of say, if you are really telling me this has happened, if you really are telling me this, then I don't think you are separated. And we have, so there's a case in Jersey, which you could probably cite in Jersey, I suppose. I don't think there'd be a difference in this respect, where the parties had one night together. And there was a fight with the registrar where they wanted to get a consensual divorce based on their separation. And the registrar said, no, you've not been separated, sorry. All because the respondent had confessed on the divorce forms that they had spent the night together, which is, nothing wrong with being honest with the court at the end of the day. And the petitioner's lawyer had a go at the respondent for having disclosed things he shouldn't, all kinds of stuff. And the court said, no, actually you weren't separated. That was appealed, and the Royal Court said, no, the registrar was right, you weren't separated, sorry. So it's quite a strict rule, actually. And that's the problem you see with divorce actually in practice most often, I would say, is the problem with understanding what separation is. So we've got the case of Mountzer and the case of Fuller are the ones that people tend to quote, which is where these principles come from, again, back in the early 70s.
Can we have the Jersey reference?
Yeah, I'll dig it out for you. God knows where it is.
So no, it's not. We could just mention.
If your law and procedure are similar, yeah, I can't see where they've
I imagine that's an issue that comes up here all the time.
Is it?
Your client's housing.
Yeah, and the reason I suppose I couldn't get my head around it from the point of view of why it was a contested hearing was when you set down the divorce, certainly in Jersey, you are required to get your clients for an affidavit to confirm that the contents of their petition are true, blah, 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 blah.
Yeah.
I don't know how in all conscience you could do that if you knew they hadn't lived separate and apart. So I didn't know how it came about really in the first place. Because I don't know how you can really do that. But that was, I thought it was a bit of a no-brainer myself. But I will find that case for you. So Mount's separate bedrooms, and the reason that's significant is that a lot of people think that having separate bedrooms is enough. It's not. They think if they've been sleeping on the couch for a year, they're fine, but that's not the case 2 took their meals together. Children were there. Meals were cooked by the wife. She didn't do his washing. They shared the cleaning. He'd stayed in the house to help with the kids, which we would say now is exactly what we tell parents to do on separation. Continue to jointly parent your children, be good parents, do it together. And that's one of the supports for divorce reform is, hang on a minute, are these rules really advocating family life post-divorce, which is what we tell everyone we own. Do these rules really help? Divorce petition, they'd not been living apart just because they didn't have a physical relationship or any affection. That was case of Fuller, which was a bit weird. Husband got ill, wife had moved out. Husband was ill and was expected to die. Unfortunately, he took a very long time about it. The prognosis was unduly pessimistic. So the husband moved, and the wife said, "Move in with me and my boyfriend," said the wife. In 1973, I bet the next stuff that. So the husband moved in with the wife and the boyfriend, but he was a paying lodger. This was on the basis that she would take care of him while he was not dying as quickly as was expected, and he stuck around for 4 years. She did his washing, cooked his meals, and he ate with the family. They were able to get divorced. No doubt on the basis that there was a commercial element to this agreement. Essentially, she was his landlady. So it was a different kind of setup, a non-domestic arrangement. But yeah, difficult to reconcile those rules, as I say there, with what we expect of parents following separation. You know, we spend our lives lecturing parents about being good parents following on from divorce, and yet these rules are sort of impose on them exactly the opposite of what we're asking them to do. Active consent is required, okay, to a petition based on a 2-year separation. It's not enough for the respondent just not to send the papers back, they have to send it back with their consent appropriately evidenced. And the forms that are served on the respondent basically give them the lowdown on what they're signing up to as well. If they give their consent, they can withdraw it. That does happen. And you can give conditional consent. I have done once or twice. I had one case where I said, okay, we'll give our consent, but on the basis that you don't apply for decree absolute until the money's been sorted out. And that was because there was a very valuable pension involved in that. If you passed away before the divorce was finalised. And that was fine. Sometimes it's conditional on costs. Sometimes you give consent conditional on the petitioner paying the costs of the petition. And the proceedings as a whole, that's fine. I think. And you can withdraw your consent if you want to. Only up to the provisional order. After that decree and eyesight, you're sort of stuffed. Reconciliation, you can be not living separate for 6 months and get away with it, but you can't use that as part of your period of separation. Which again I think is daft, but there you go. So you can have a period of 6 months where you're not living separate and apart. It doesn't mean the clock restarts, but you can't use that period as part of your period of separation. And if it's more than 6 months, then you are stopped. So if they had their one night of goodbye passion towards the beginning of their separation period, it's not a terrible circumstance, but
essentially just adds on whatever that period is to your 2 years.
yeah, it can't be more than 6 months.
So sorry, how can, so they are a year through and then they have a goodbye session, surely that would fall within this.
Depends whether, I don't think resuming living together isn't the same thing perhaps as having sexual intercourse or having a night of passion.
So they can actually get
I don't know is the short answer.
So they separate for a year, they get back together for 4 months and they live together. And then they think, you know what, it's not working out. But well, they've got to do another year on top of that.
Yeah, they can't use that period.
No, but they can.
It doesn't necessarily
Okay, fine.
reset the clock
Okay.
if you
Doesn't
can
reset
put
the clock,
boundaries
doesn't-
around it, but you
doesn't
can't use it. So
Yeah.
it's going to add at least 6 months to your.
Yeah.
That's
So instead of it being 24 months in that scenario, 28,
yes. But I just can't, you know,
they give it a bit of a breathing period.
get. You know,
Also implies that you would have this, that it would be really easy to identify what the period of time was and why people don't live their life like that. If they have a period of, it tends to be, if it's going to happen, a period of coming and going. So very difficult actually to, one of the problems with formalising protection for cohabitees is actually defining when cohabitation starts and when it finishes, and what level of protection you should give people where the different kinds of cohabitation are happening. So quite difficult probably to draw a bubble around a 6 month period or less than 6 month period during which you weren't separated, when there's probably been some mission creep either side of that. It's very difficult to use that. I would say very difficult to use that. But that provision is there. In Article 9.8, as I read it. Separation for 5 years, same problem really. Financial protection for the respondent in separation cases. 5 year separation without consent is one of the examples of, again, why divorce reform is gathering pace, because in theory, you can defend a 5 year separation case on the basis that it would cause you grave hardship to get divorced. The existence of that potential defence means that it is legally possible never to be able to get divorced. And a lot of people are very uncomfortable with the fact that it is possible that you could end up in a situation where it is physically impossible to get divorced. It is unlikely to happen much in practice because the court's ability to give financial relief means that it's very difficult to see that you're going to have situations where someone can't get divorced for grave hardship, because the court will make sure there is no such grave hardship. But it is legally possible to be in a situation where you can never get divorced. There is a debate about whether that's contrary to human rights. The Convention on Human Rights includes a provision saying that you have a right to marry and to found a family. It does not say you have a human right to be divorced. And one of the reasons it doesn't say that is because there are far too many Catholic countries who are signatories to that convention. So there is no human right set out legally to get divorced, but in theory you could be in a position where you are trapped in marriage forever until you die. Very unlikely to happen in practice. But where a divorce is going through, one of the questions that you're asked in the standard forms is, do you want the court, if this is a separation case, to consider your finances as they would be after the divorce? Has two effects. Sometimes people will defend the petition on the basis that they have would cause them grave financial hardship. It can also be used to delay a decree absolute, so to stop the petitioner obtaining decree absolute if, for example, it stops you from benefiting under a pension. for at least a period of time. The court is also not required generally to pronounce decree absolute if it decides not to. The rules certainly in Jersey say that the court may award decree absolute, not that it necessarily has to. Judicial separation can be useful to prove that you've been separated. The other thing it's useful to remember is that if you use a fact as the basis for a judicial separation petition, you can use the same fact in the following divorce. That's fine.
You could get separated and be separated for the rest of your life without being divorced.
Yeah.
You'd never be able to remarry.
And you'd always be you'd always be stuck with the inheritance implications as well. But some people do choose to live their lives like that. Some well-known divorce lawyers in England have been separated from their spouses for many, many years. And never divorced.
The inheritance petition, we have one.
They know the law too well.
A free testamentary, freedom testamentary.
Complete freedom, no dependence act or anything like that. Yeah, it's rare to have complete testamentary freedom. Jersey's awful. We've still got leisure team. Yeah.
Okay.
Yeah. If you have any clients that have property in Jersey, be very, very careful. We still have leisure team. We still have rights, dower. We still have disposable thirds. All of that is still part of our law, as is partage on intestacy. And we've only just recognised illegitimate children. So if you've got clients with property in Jersey, be very careful. Yeah. We've been talking about changing the law as long as I've been away.
There must still be a lot of people whose wills are under the leisure team rules.
Yeah.
I'm wanting to make a new one and do a pricing.
And how many of those wills will say, in observance with the customary law of Guernsey, I give leisure team? A lot of them. All firms should have completely reviewed their will safe to check that, and most of them won't have done, guarantee it. But a lot of, because the advice would be, no, you can't, but you can tell them the law has changed. Because a lot of people will follow the leisure team position because they want to avoid a challenge from their family. We still have reduction ad legitimum modem, all that kind of stuff. So yeah, be careful of that. Be very careful of that. Okay, so same-sex Guernsey law, unsurprisingly, not that different to divorce for couples who are heterosexual, you would expect it to be, but we don't have adultery for same-sex marriage couples. They can't get married if they're in a civil partnership with another person. It won't be a Guernsey civil partnership, but they could have a different jurisdiction. They have the same rules on consanguinity, which is slightly weird because everybody always thought that consanguinity, which is not marrying your brother, for example, was based on the fear that it would lead to genetic problems with children, for example. But it wasn't a good thing to breed with people you're closely related to. But the fact that it applies to same-sex couples would suggest that there's a different societal reason for that to be. So pretty much applies in the same way.
So the only thing not open is divorce on the grounds of adultery.
Basically, the sex stuff is different. So the nullity stuff is different. Consummation is different. There's no requirement to consummate gay marriage. And you can't commit adultery. Only conduct between the respondent and a person of the opposite sex constitutes adultery. or rather they couldn't commit adultery with a person of the same sex. And yeah, it may be easier to claim jurisdiction, but jurisdiction is slightly different as well, where you've got people married under the law of Guernsey. So I've given you a little example there, Adam and Barbara. Let's have a quick look at that and maybe have a break for some munchy. Adam and Barbara, classic exam question kind of a thing. Married for 4 years, baby Charlie. Both Guernsey born. Barbara has a child, Dominic, who's 5. Adam has treated Dominic as if he was his own child, which potentially makes him what? Child of the family. Adam used to work for a local law firm where he met Barbara, or where she also worked. She no longer works because she has a Charlie. Adam's been critical of Barbara throughout the marriage. She struggled to get back in shape. He's been rude and sarcastic about her weight and made her cry. That kind of thing is very common. Adam does not find parenting easy, so she's been the one taking care of Charlie. She's been diagnosed with mild postnatal depression, which has affected her mood and her behaviour at home. Adam's had an affair with Emma, which ended 8 months ago. Barbara suspected the affair and found a hotel receipt in his wallet. She didn't ask him about it. She started drinking. She became aggressive, slapped him a couple of times. He's also been harassing her girlfriend. She's also been harassing his girlfriend on social media. That's very common too. She's lost her job. He's suddenly left her. He's written to her saying he's taken up a 3-year contract with a larger law firm in Jersey where he's got better prospects. He's not sure if he's ever coming back. She wants a divorce. Can she divorce him in Guernsey and on what basis?
There's everything in that.
Yes.
Yes. Okay. So in relation to the fine, the affair ended 8 months ago, which is outside of the 6 months to bring an adultery petition.
Work all the way through it from the beginning is what I would say. Remember who you are advising.
So yes, she could pursue divorce.
Oh, you've reached a conclusion. You haven't worked through the question. Well, please work through the question first.
Do they have a valid marriage?
Yeah, you are going to need to consider who you are advising. Does the court have jurisdiction? Does the Guernsey court have jurisdiction? And then you're going to have to look at the facts. And when looking at the facts of divorce, remember that you are advising Barbara. So does the Guernsey court have jurisdiction?
Yeah.
Why?
Because she lives in Guernsey and has no past problem.
Also, they're born there, so you argue whether any domicile would have changed.
Chances are at least one of them's got domiciles.
Yeah. So we've got domicile.
Yeah.
There's no time limit that you have to be married for in Guernsey.
Yeah.
But in any event, you've been married for 4 years.
Mm-hmm.
There's 1 child of the marriage and father and 1 child of the family.
Yeah.
So then from here coming to pay for finances.
Relevant to finances, the other reason I mentioned here is because you're going to have to, I think you have to state them in the petition, but you certainly would do in Jersey, you have to list children, family and marriage.
There's a whole separate document called a statement of needs that we have to draft.
We have to actually include them in the petition as well. We have to name them in the petition itself. I'd have to check whether that applies to you as well, but it's important to include children and family at that point, particularly for acting for the mother. Because if you don't include children and family in your divorce papers, you may struggle later on to try and claim financial relief. Because it's not an assertion you have made. I'd have to check, but certainly in Jersey we are required to list children and family. in the petition itself as a requirement.
But this is a
And
step
certainly in
child.
Form 5, children of the family, as opposed to you must take children of marriage and children of the family generally. And if you don't set out your stall at the beginning so that Dominic is a child of the family, you're going to struggle to get financial provision for him later. So he'll certainly be in your, for us it's a Form 5, but your statement of arrangements for children, but I'd have to check, we would include him in the petition. I'll have to check that. Okay, so irretrievable breakdown of marriage, you know, is your ground. So in the second paragraph there, is there anything relevant that might establish a fact?
Yes, he is being rude and sarcastic for a week, reducing her to tears.
Yeah.
Behaviour.
Is that sufficient to be a fact?
Only if she then finds it intolerable to live with him.
Which lowering her self-esteem.
Anything in her personal characteristics which could make it more compelling to think it's unreasonable for her to live with this?
She doesn't work, so may not have any means to support herself and the children. If she's a family carer, to live elsewhere.
And she's been diagnosed with postnatal depression, which could make her particularly susceptible to that kind of behaviour from her. Couldn't it? Now you've got a hint there that it's affected her behaviour at home. Okay. There are a number of facts in this question which relate to her behaviour. Okay. Can she use those as a fact of divorce? No, she can't.
That's the respondent's behaviour.
Yeah. So Vika, that's partly why I say think about who you are advising when you are answering problem questions.
She has been pretty aggressive to him and snapping him because she finds in the opposite circumstances his submissiveness infuriating.
I have seen lawyers say his behaviour was so bad it drove me to a position where I did X, Y, and Z, and to plead that as behaviour against the other party. I have seen that. What are you sort of begging for? Cross petition, are you?
Yeah,
Yeah, so I mean, I personally wouldn't find it an attractive thing to plead. I have seen people try and do it, but I think you are asking for a cross petition. And you may get one anyway, so that's one of the things you'll have to be advising Barbara. Question doesn't necessarily ask you, but in terms of brownie points, you will be saying to Barbara, look, there is a possibility that you could find a cross petition level that you know for your own behaviour. Okay, so third paragraph. What's going to be relevant there? You've identified brief affair with Emma, which she ended 8 months ago.
it says beyond the 6 month window.
And then you've got her drinking and her harassment of poor Emma.
Again, that's her behaviour.
It's her behaviour. Yeah.
We advise her to stop doing that.
You'd also advise her to what, in particular, if she wants to keep her children? Yeah. Alcohol and parenting do not mix very well. Neither does hitting their father, but alcohol in particular does not mix well with competent parenting. Right, there's one more hiding there at the bottom of that paragraph, potentially.
He has, or is it telling without telling her his plans? If he's never going to return, how is she going to know?
Is it desertion or not?
Yes.
This is one of the problems with desertion, actually, is working out whether they've whether they have had the appropriate intention.
She does. Never wants to.
Has he
Oh,
deserted
he's
her?
unsure whether or not.
Has he deserted her without cause for a start?
No, not really.
Bearing in mind her being a bit drinky and a bit slappy and a bit and a bit vile and abusive towards other people. So is there an argument he may have left her for cause?
Yes.
And yeah, he seems uncertain of his plans, doesn't he?
Mm.
Yes, he's taken a 3-year contract, but is that enough to say that he won't return to her? Well, he could be working in Jersey, but still not have deserted the relationship for 3 years. He could arrive next weekend with a suitcase. Stay for the weekend, whatever. So I think desertion, I think, is always quite a difficult one to establish, actually. Yeah, so can she bring a divorce petition?
It's very difficult.
She probably can, but she might get one back in her face. I suspect. Depends how keen he is to get divorced, perhaps.
But then would you advise if there was a cross petition that she didn't defend it, stopped her petition? For example, if he did it on behaviour, she told you she can't deny those things. So if she then didn't defend the cross petition and agreed to withdraw her petition.
Yeah, if it went through on the cross petition undefended, it may be that that's what she wants. There might be some difficult findings for her, which could be in a dispute around the children. Difficult. But on the other hand, he's walked out and left her with those same children. So he can't be that worried, can he?
And even leaving without seemingly any plans for contact with the children,
Yeah.
would that be a behaviour?
It doesn't suggest, yeah, I mean, he's, if he has left her without financial assistance or provision, I would plead that. If he has left her without seeking any form of contact with the children or showing any interest in the difficulties the children will experience, I'd probably plead that. He's certainly not up for Father of the Year award.
Yeah.
And think, I guess, about how you would serve your petition if he is in Jersey.
Do you apply for service to your work address?
I think under substituted service, you can apply for pretty much anything. People are imaginative. I have done service by Facebook. Serve on Facebook. You can service by email is common, provided you can prove that they are receiving emails at that address. So all kinds of things. I've done service on parents. Where I'm confident it has, well, with an order saying it's good service, it has been. And I think I've got one case where I served on professional services firm, I've been an accountant or something like that. Basically, what the court looks for is comfort that it's going to come to the attention of the other party.
Do you have A, B, and C service that we do?
What do you mean?
So if it's, I think it's if it's A service, it's direct to who you want it to be. It's B service if it's somebody who lives in the same household or wife, or you know it, or C if it's just left there.
Okay. We tend to have personal service, which is personal service effected on the person by the Viscount normally. Or we have postal service, which is normally post to the last registered address. And there's some weird and wonderful rules around that in terms of when it's deemed to have been received and all that kind of stuff. Or we have substituted service, which can take pretty much any form, but you have to plead what you want and have an affidavit in support. But you can have anything. it has to be the best route possible. Sometimes people vanish and you don't know where they are.
Yeah.
Honestly, don't know where they're. The last one I had, he'd vanished off to Canada somewhere, actually, but we didn't know where he was. And we had to serve it. We served it by email and by post to Canada to the home of one of his adult children, where we knew he was in contact with her. And we could show he was in contact with her. And we got an order for subservice on that basis. But we had no way of knowing where he was going to be.
But that's why you have to leave it to say, oh, you tried to.
Yeah, and why this is the best route possible. And then you cross your fingers and hope they send back the acknowledgement of service, because of course if they do that, you can prove they've received it. Right.
So she is likely to be able to divorce him.
I think, yeah, she's likely, you would certainly have enough there if she wants to go ahead to bring a petition. You could draft a petition. Which is, if he decides to be bloody-minded and defends it, might be quite hard to prove some of these allegations if he denies them. They're unlikely to be witnesses to them. And certainly she is at risk of cross-petition. And she just needs to be aware of that. It needs not to come as a horrible surprise, I would say.
Would you go over the separation facts? Or would you just assume that
she wants to divorce now? I mean, certainly part of your advice would be, or she could wait and achieve a separation by consent after 2 years, if Adam is in the same mindset, and provided they are able to move forward and consider, for example, ancillary relief and arrangements for the children. There's no immediate rush to divorce. So she needs to be aware it may not be essential for her to do anything at this stage in terms of divorce, or 5 years without his consent. It is likely he would consent after 2 years, isn't it, these facts?
Yeah.
So a lot of it comes down to timing. Do you absolutely need to issue divorce proceedings now?
And then if it's a separation of consent, the clock then starts running once you've issued, doesn't it?
What do you mean?
Once you've issued your petition, there's a 2 years run from that date.
No, because you issue your petition, they have to have been separated for 2 years on the date of your petition. So your petition is issued on after 2 years of separation.
Then you say psychological signs when you're at the problem. It's normally good to get in there first.
I wouldn't say normally. Sometimes it's an important factor for them to be on the front foot, and petitioners often feel a bit more on the front foot. That's not a legal issue at all. It's something really to discuss with them. Is it important to you to have a divorce right now? Or is it more important to you to sort out the money and the kids and to try and do things amicably? The answer is generally it's more important to sort out the money and the kids. People are very rarely actually worried about the divorce itself. Rarely. Sometimes they are, but it's quite unusual. They're normally just worried about sorting stuff out. And provided you can do that without divorce, it's quite often not a matter to do. And you could, for example, have your judicial separation by consent if they can agree some financial issues, or the financial issues. There may be no need to have a potentially confrontational divorce. Right, the procedural stuff I've put in here for divorce and separation is fairly, is what it is really. A little bit boring in terms of having much to say about it. You need to be familiar with how you go about issuing proceedings, basically what forms you need to fill in, what the content of your petition has to be. Important to understand how you make service.
Yeah, you mentioned the contradiction. Court of appeal. So in that case, did you say people generally go for 20 weeks?
Yeah, Adrian tells me that the longer period is the one that applies. And you have to state what attempts you made to reconcile in the petition. What all your papers have to say, how you defend them. Do you get many defended divorces? I'm assuming not. I've given a couple of activities which we won't do today, but they're things that it's useful for you to be able to do. You have Form 1A for divorce petitions here, so try doing one, Barbara. See how you would put it together. Think about what forms you would need to produce if you were acting for Barbara, and think about how you'd serve them. And think about Adam.
Type question drafting a petition.
I doubt that you would get that in an exam. It's the kind of thing that would have cropped up in Jersey in an exam question 20 years ago. I think I was asked to draft a will. I don't think that's what your exam centre are really looking for, but I'll have a look at the past papers that you've had over the last X number of years. I think it's unlikely, partly because it's actually no test of your knowledge to be able to fill in the form. Anyone could do that. I'm not being funny, but as long as you know what the rules are, you can draft a divorce petition and in fact fill in the divorce form, which is the way that you do your petitions. So I would say not, but if that changes, I will let you know if I think that you're right to be answered that kind of question. Traditionally, it's more problem questions. Yeah. And think about what you would do for Adam. It's important to, you may in exam questions have to know what the procedure is. So Adam's received these papers. He's in Jersey, but he's been told to take advice in Guernsey, which is wise. What do you tell him to do? What's your advice to him on the same facts? Reverse the person you are advising. What advice do you give him?
If you were approached by Adam, would you do a question?
I would certainly tell him that at the end of the day, the client's the ones who make the decisions. So I think you could say, look, you're telling me that what she's saying is true. If you want to accept it and move on with your life, fine. You do, from what you are telling me, potentially have grounds to cross petition, but you might think there's no point and it costs money. But it's your decision. You have those grounds, I think, if you wish to do that. That's probably what I would tell him.
Would you want to talk about children and housing relief?
I would at least open the subject. The urgent issue is going to be talking about divorce, and certainly because that's something, if that's the case. But I'd start talking to them about what are your plans in relation to the children? Have you arranged contact? What do you think about contact? Start to think about the position of Dominic as a child of the family and how he sees that working out over time.
How do you, or do you deal with one party who is not concerned about having contact?
You get them every now and again. I think all you say is, look, think about where you see your relationship with that child being in a few years' time. Do not assume you're going to be able to pick it up. You do see quite a lot of dads who will say, the next few years, I'm just not in a place to really think about this. I'm not in a place for this child to come and stay with me. He's better off with his mum. She's going to say horrible things about me anyway. I'll sort it out later. You know, we'll have a good relationship later on. I'll just let this period go by. that's very dangerous. And I always advise dads, look, if there is a break in your period of contact, it is much harder to re-establish your relationship if you let that relationship go. Do not assume you will be able to do it at all. It may be that this child never gravitates back in your direction, so it is important that you try and have a relationship with them. But beyond that, there's nothing you can do. I occasionally get dads who offer to sell contact. I had one who agreed with the wife that he would not pursue contact if she didn't ask him for money, and I sacked him. Now, not all lawyers would have done that, but I told him I couldn't act there. I didn't sell children. But not all lawyers would have reached that conclusion. But certainly it's not something you can ever put in a court document. So yeah, not all dads want to have relationships with kids. Not all mums want to have relationships with kids.
Yeah, it works both ways.
It does work both ways. Yeah. It's less often, but less common, but it does happen. Certainly does happen. Sometimes where mums have new partners who aren't interested in their children, they will walk away. That case is where that's happening. Yeah, it's very sad for kids. Doris and Edward, married 5 years, no kids. They've grown apart, have nothing in common. Haven't had a bedroom together for 2 years, don't socialise together. Doris is a brilliant cook. She does shop and cook meals. Edward does his bit by doing the cleaning, have a joint bank account. Edward has a new lady friend that he hasn't yet had sexual intercourse with. Can Doris divorce Edward?
Sounds unlikely, doesn't it? The separation issue doesn't come in because she's clearly not finding his behaviour intolerable.
Oh, don't forget, she could find his behaviour intolerable to live with and still be under the same roof as him. She could.
A fact is the behaviour.
His relationship with the new lady could be behaviour.
In such a way that the petitioner cannot be.
Yeah, it's having a close new relationship with a new girlfriend, essentially, even if it's not sleeping. It might be.
It's not the behaviour that's unreasonable, it's the unreasonable.
The expectation of continuing cohabitation. So, is she likely to carry on doing all his cooking and shopping for him? Perhaps not.
You can say they've tried to have separate lives, they've failed, but they've tried.
But you might try behaviour. This is the nonsense. This is the nonsense of divorce. Yeah, a lot of couples who are separated carry on with joint bank, particularly where they still own a house. Because if they're paying the mortgage, they're going to have a joint bank account. And a lot of people where there's only one party working, in particular, will just carry on. Now, certainly in Jersey, they wouldn't bounce a separation petition on that basis.
So, do you think that she could bring something?
I don't think she could bring a separation divorce. I think she would struggle with that.
Yes.
I think if it wasn't defended, she would probably get away with a behaviour divorce.
And I guess it would be likely on the fact that it wouldn't be defended because
they both want to move on.
they've grown apart,
and he would plead it in such a way that him having developed this relationship with the new lady has changed the landscape to the point where she no longer feels that this arrangement can continue.
But importantly, it's not adultery because they haven't had sex.
No, so you might get away with behaviour.
I don't know the bottom one, but how long does it take?
Well, this uncontested behaviour fact to establish the ground for, then it could be.
So it's petition, 60 days. Then
that's your provisional order, isn't it? After 60 days. And when do you get your final order? It's just to see really whether you know what the timescale is for an easy uncontested divorce. If a client says to you, how long is this going to take? What advice should you give them?
I don't know how long it has to be between provisional and.
Yeah, there is a 60-day gap between the petition and the provisional decree, if I understand it.
Yeah, half months to obtain and a divorce if the application is not.
It may take 3.5 months.
Yeah, but that's a guideline.
That's a guideline. I don't think there is a, I'm not sure if there is a strict rule. You have a provisional order hearing, which sits every couple of weeks. Final decree can be applied for after the time limit for appealing the provisional order has expired. So it depends what your appeal time frame is in that particular case. Either party can apply. Okay, that's unusual. And that actually makes it less important to be petitioner in Guernsey, because it gives you less control of the procedure. That's unusual. Normally it's the petitioner who applies in England and Jersey.
What page is that on?
53. Now, some of this stuff is narrative because it's not in the rules, so it's what I have gleaned from what other people have written and said.
So, I need to have a little time limit for appealing the provisional order.
And of course, it will depend a little bit how far you are away from court sittings when you actually get your 60 days, presumably. So there will be no firm answer on how long it's going to take. But the rule of thumb appears to be approximately 3.5 months. Defended divorces actually could take as long as it takes, because if you end up having final hearings, you know, who knows.
It's not more but in those who've got children, it's only required to the divorce, not really.
Not sorting out the other stuff, which could be very quick or very slow. I think the record I had was one where, in my previous firm, we got final orders, ancillary relief orders, about 10 years after the petition, and that was because the court had to overturn the original judgment because the husband had lied in the first round of ancillary relief proceedings. 6 years later, that judgment was set aside and they then had to start again. So it took about 10 years. But that's you'll never have a case like that, unless you're very lucky. That was wild. All right, should we have some lunch? Yeah. Now, I'm apparently leaving at 3:45 my taxi, so I guess we'll have to wind things up about 3:30. So if we have a look at money this afternoon, is half an hour enough for lunch, or do you need longer than that? Okay, I'll just go and grab a quick sandwich, because that would give us, if we start at 1, it gives us a good 2.5 hours to have a proper look at money.
I'd rather make the most of what I'm doing.
Yeah, now I'm in your hands.
Okay, fantastic.
Okay, so half an hour and then we do money. All good stuff. Right, so moving on to money, which is what most clients want to know about, to be honest, is what they're going to get and what's going to happen with their kids. Those are the two questions that most clients have to start with. The problem with advising on money is that it is impossible to say with any kind of certainty what a client is going to get. And that often disappoints them, so you have to be able to explain why that's the case. They think there's going to be a formulaic answer, and you'll be able to say to them, yes, you're going to keep the house. Yes, he's going to pay you half his income. Yes, this is going to happen, and you don't have to worry about it. And that's something that you have to cope with every client, because that uncertainty is something that people don't appreciate is there. It makes it hard for you to give advice. It makes it quite hard for you to know when to settle a case and when to take it to court, because you never know whether what you're going to get out of a judge is better than what is on the table. All you can do is give it your best opinion and advise the client as to what the risks are. It's also very expensive to go to court, to have fully contested financial proceedings. It costs a lot of money and takes money out of the pot. So it means that people are less able to afford the stuff they actually need, houses generally, or other debt repayments. So that's tricky. Another area where you'll inevitably disappoint a lot of your clients is that the law on money doesn't make distinctions between good partners or spouses and bad partners or spouses, generally speaking. People will not be punished because they have been naughty. And that comes as a big disappointment to a lot of clients, and pretty quickly. They assume that they are going to come better out of things because their husband left them for another woman, or because their husband has been horrible to them. It's very difficult for them to grasp that it doesn't matter, actually. Women these days are finding tough the fact that they are going to have to make the most of their lives. So it's incumbent on people who are weaker financially to do the best they can to become financially independent within a reasonable period of time. And that comes as a nasty shock to some women. The law, what's particularly important in the law is the concept of discrimination. In around the year 2000, the law changed fundamentally with a case called White and White in the UK, and Guernsey law has followed that case. Up until that point, people got what they needed. So if you had a richer spouse and a poorer spouse, generally the one who'd been at home with the children, the wife would get what they needed, but they wouldn't get beyond that. White and White popped along and said, no, that's discrimination against women. We can't be having that. It's not human rights compliant. And we're going to treat the parties as equals. There are two sides to that. One is that Britain has become a very popular jurisdiction for divorce for women, who are getting larger awards than they are in most other parts of the world, if their spouses are rich. The flip side of that is that discrimination means that people are expected to do the best they can to make themselves independent. Because if we don't discriminate, we don't discriminate. We expect people to make the most of their lives. So there are two sides to discrimination. But that is a big feature of how we divide up money in these jurisdictions. And the general overriding principle is that we do what is fair or just. That's pretty much all the law actually says. We do what is fair or just. That leaves a lot open to the imagination. So the court has some guidelines that it applies. Some of them are in statute, some of them are case law principles and guidelines. The idea being that if you follow them, you are unlikely to come out with a decision that is wrong. There might be 50 or 100 or 1 million correct decisions, all of which are fine but different. But you're unlikely to come out with an answer that is fundamentally wrong if you apply those principles. The first step in any jurisdiction is to understand what the court can order. So physically, what orders a court can and can't make. So generally, you'll be dealing with money because you've had a divorce in Guernsey. Bit of a moot point whether the court can make financial orders after a foreign divorce. But certainly divorces where they are in Guernsey, the court has a certain number of powers, not very many, which are set out in your matrimonial causes law. And I set them out starting on page 55. Article 43 is to do with children and provision for children. After the making of a decree, the court can make long-term orders for child maintenance. Where the parties are married or have been married between spouses, the court can make long-term child maintenance orders. You cannot use Article 43 for a couple who are not married or were not married. So cohabitee parents, you need not apply under that article. So the court can make long-term orders after decree, and it can make interim orders prior to decree. After decree, it can make interim orders prior to decree. So it can do short-term orders for children in the run-up to that decree being given, and a final hearing in relation to money normally, and long-term orders at the end of the day. And those long-term orders may continue for the rest of the child's childhood, may, because they can be reviewed. They might include provision for school fees, they might include things like university fees, or even gap years, although that's less common in my experience than it used to be.
Would there ever be an order to say this is up until further education and come back to the court at that point?
Yeah, sometimes in Jersey what we do is we say we'll have a review if the children go into tertiary education. Be careful how you define further tertiary and higher education. If someone is doing, if you've got an 18-year-old who is doing a one-day release course in hairdressing whilst working, are they in further education? And is Daddy going to pay maintenance for them? So be careful what wording you use. Make sure you're saying what you mean. But yeah, you can have a review. In Jersey, certainly, we're quite careful because it can affect things like grants if you have particular provisions in orders about costs of further education. And we don't have student loans or anything like that, so tertiary education costs can be very large. About 20 grand a year is about average tertiary education. So that's kids. Article 45, power to vary settlements. Not used massively, I have to say, in Jersey. I don't know if it gets used much in Guernsey, does it? No, I mean, most people in Jersey, we look blankly at each other when we're asked what it means in a way, because it doesn't get used very often, but the court does have the power to vary settlements. And that's after a decree of divorce, so it's a long-term order. Article 46, the court can order vesting or division of property. That, for your purposes, is one of the big ones. Okay? So child maintenance and power to vest property or divide it up. Not to sell it. And that applies on decree, not before. Court can't go around ordering transfers of property, or shouldn't, before that decree has been made. There's a long-term orders. And Article 47 is maintenance, spousal maintenance, essentially. And again, it can make a long-term order after a decree, or an interim short-term order where a decree hasn't been given. Okay. So actually, quite a small number of articles there really set out what the powers of the court are. But they're quite wide-ranging because, in essence, what you are saying is that a judge has the ability to reorganise parties' finances. It is unusual. Your judges don't have a power to order sale of property. It's unusual. But they find other ways of getting around it. Why they don't, I'm not sure. couldn't find anything that told me why they don't. But it seems they don't. So what does the judge do? Well, the first thing a judge has to work out is what the finances are. So you have a process under Article 51 and under your rules for parties to make financial disclosure. And that's why financial disclosure in family cases is so important, because in order to fairly decide how you're going to divide up the assets, you have to know what there is. And you only know what there is if the people tell you, because actually the court has no way of knowing what the assets, liabilities, and income and expenditure of the parties are unless people give an honest record of what the financial situation is. Very difficult for the court to make orders in a vacuum, which is where adverse influences come in. So I set out page 56 onwards a little bit about each article. Support for children. Court can make such orders as are just in relation to maintenance for children whose parents' marriage is the subject of the decree. Now, I am not entirely sure, and it may be a good idea to ask Adrian or, in fact, someone that you work with, whether in Guernsey that is taken to include children of the family, provided that the parent has been married to the other spouse. So normally what I'd expect to see is a provision that would say maintenance for children of the marriage or children of the family. What it says is maintenance for children whose parents' marriage is the subject of the decree. Okay. The court has complete discretion in theory as to what it gives you in child maintenance. Unlike in the UK, where it's very formulaic. In England, it's all done by what used to be the Child Support Agency. So the vast majority of cases, unless they're very high incomes, are completely outside the jurisdiction of the Matrimonial Causes Division. They're collected by an agency. We have a different way of doing it in the Channel Islands. The court has complete discretion, but it tends to use as a benchmark the awards that would be given under the Child Support Agency guidelines in the UK. And as a rule of thumb, that's 15% of your net income if you've got one kid, 20% if you've got two, and 25% if you have more than that, or more children. There can be adjustments to that for various things. If a child is spending a lot of time in the home of both parties, there could be an adjustment if dad physically can't afford it, or if the children have particular needs, or if there is things like school fees to consider, that's got to be factored in as well. It could be that if dad's paying school fees, he can't afford that full whack of maintenance. So the court does have some wiggle room. It's not tied like it is in England, which is quite useful. Generally, it's going to be until they're 18 or until they finish full-time education. It's at least secondary education. You quite often, as I understand it, index link them. We do in Jersey as well. And we consider school and university fees separately too. Case of E&E on child maintenance, I've given you duty of every father to pay reasonable maintenance for his children. He was told to pay at 20% of his net income until the kids were 16 or finished full-time education. Be careful if using the words full-time education in orders when you're representing clients, because that could well include university, and most men do not want to pay child maintenance to their wife or their husband or children who aren't living at home. They might be happy to pay university living expenses, but that's slightly different to carrying on paying child maintenance. So that can lead to arguments. Costs are at the court's discretion in family cases. That's the general rule in civil litigation in Guernsey, as I understand it, and that applies to family law. There is no general rule that costs are going to be, or costs are not going to be awarded. Often costs, as I understand it, aren't awarded because awarding costs just generally makes things worse financially. But certainly if you do badly in a case, as I understand it, people here are at risk of going down with a cost order against them. And they need to be slightly careful. In the UK, there are specific rules on costs, but you don't really have them here. Article 45, variation of settlements. After decree, either party or any person with a beneficial interest, so not even the party, can apply to cancel, vary, modify or terminate the trusts of a marriage contract or settlement, a post-nuptial settlement, or terms of separation in any manner, which, having regard to the means of the parties, is just. Okay. What that means in practice, I don't know. I note with interest that it includes a post-nuptial settlement, which under another provision might be said to have no validity. I'm not sure what that means in practice. Not sure. I suspect it's very rarely used. It's very rarely used in Jersey. Could apply to things like trusts. And one thing you might like to think about in your practice with your colleagues is the extent to which that could be used in relation to a Guernsey trust. Or used by Guernsey litigants, where there's a trust outside the island. It's one of those that people look at these provisions and say, oh, I'm entirely sure what they mean. But they could certainly come in handy where there are trusts and settlements floating about. Also in A&A, used to consider the variation of the terms of the judicial separation. Because in that case, the husband, having achieved his what seemed quite unfair judicial separation, trying to get it varied. So I suppose that is a post-nuptial settlement.
Did it work?
I think they changed maintenance. I'm not sure they changed the rest of it actually. And maintenance generally is always subject to review, partly from a common sense point of view, because you can't get blood out of a stone. And if someone's earnings plummet or dramatically go up, it may not be fair to the person in stone. Vesting or transfer of property, Article 56. Court can make orders in relation to the property of either or both parties. That applies to real or personal property that they have an interest in. So by definition, I take that to mean it could be a beneficial or legal interest. That sometimes causes problems with property law in Jersey. I don't know about Guernsey, but we don't recognise beneficial interests in land in Jersey. I don't know if you guys do.
I do know that we do. I'm not sure.
Important for a family lawyer to know that stuff, I would say, even if it's not part of your syllabus, because it causes real problems where you've got someone claiming a beneficial interest in land. Let me give you an example. A couple are housed by their parents, one of their parents, for 2 or 3 decades, treat the house as their own, spend a lot of time and money on it, blah, 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 but the house remains in the grandparents' name. It's always understood that they're going to inherit it in due course, but they break up. Does wife have an interest in that property? Causes all kinds of problems in Jersey because we don't recognise beneficial interests in land. We don't accept trusts of land either. So you can't hold land on trust for someone. So the point of mentioning that really is to be aware that different areas of law impact on the advice you give a family, inheritance being a big one and property law being massive, in terms of understanding how you can own property. I saw one of your cases, for example, which talks about the ownership of a house being transferred into ownership in common from joint tenancy, which is fine, just means joint tenancy means you both together own the whole thing. If you hold it as tenants in common, it's sort of chopped down the middle, so you each own a defined share. Fine. In Jersey, you couldn't make that order because no mortgage, no bank would lend against a property that's held in ownership in common because it's very, very difficult to enforce the debt. So it's important, I think, for every family lawyer to have a grounding in property law, and probably everyone dealing with estates and trusts as well. because property law in the Channel Islands is weird, partly because it drives some French law.
You can't own property with his tenants in common.
You can, but you won't find a bank that will borrow a lend against it. Well, in Jersey you wouldn't. It may be different here, but it's a problem in Jersey. I don't know about your property law.
In the UK, of course, there's only one way that you can hold land legally, that's joint tenants, but underneath you have the tenants in common.
We do have tenancy in common. That's absolutely fine in Jersey, but banks you'll find in Jersey will not lend against it because of difficulty in enforcing the debt.
So does that mean that if two people then buy a house together, it's as joint tenants?
Yes, inevitably.
Such that on the death of one, it automatically passes
Survivorship, yeah.
No.
Yeah. Very, very rare to have tenancies in common in Jersey.
So how could you get around that? If two
You don't get around it.
So if two people wanted to live together, they could not just as cohabitees.
They enter into prenuptial agreements or cohabitation agreements. They've never been tested in court to see how they would work.
So then there's no intention of getting married, they just want to buy a place together.
It just goes to the survivor fund.
Yeah. And they make sure that there's life insurance in place to which benefits their estate so that it's not unfair if anything goes horribly wrong.
Is the alternative undivided home shares?
Yeah, essentially, I suppose that's what a joint tenancy is for most people, is that undivided joint ownership. We can't, you see.
Isn't that the same as a tenancy in common then?
Well, it depends whether a bank is happy that they can enforce their security. That's what it comes down to. It could be that Jersey is particularly problematic. So I think the point really is that it is worth spending a bit of time with your property departments, talking about how property law works in the concept of the breakdown of marriage. Can you have trusts of land? What happens if there is a joint tenancy? Will banks lend against properties that are held in common? How is it ever a problem? What happens? But I think all family lawyers should have a working knowledge of property law in any jurisdiction.
There's already a property in a family.
There is normally a property. There is normally a house. And of course, there may be houses in other jurisdictions, so you may need to make some inquiries about what the law says there as well.
Could you have an underlying? Did you say that you could not have an underlying declaration of trust?
In Jersey, it would be invalid. We cannot have a trust in land. The only workaround, if you will, is to have a property owned by a company, and for the shares in that company to be beneficially owned by, say, a trust, or a company owned by a trust generally. But the stamp duty implications are massive, so it tends to be tricky. It's very expensive from a stamp duty point of view, but that's the only workaround, beneficial ownership. Can't have a working trust of land. That may well be different in Guernsey, but it's important that you have an understanding of property law. Otherwise, you won't see the problems, and it's easy to draft an agreement, for example, or a consent order, which is unworkable.
I think it is worth thinking about property, but I think if it was in undivided shares and you did subsequently get married, you could put it to joint tenancy.
Yes,
Like
you can do that. You can do that again if a bank will let you. What happens in Jersey, because housing qualifications is such a big deal, is that quite often where parties want to buy a property but only one of them has housing qualifications and they're not married, they will buy together, but the house will have to be in the name of the person with the housing qualifications, even if the mortgage is in joint names. So they have to enter into a cohabitation agreement and cross their fingers and hope that it's not a problem. And then when they marry, the house is conveyed into joint names. That's what tends to happen. But yes, it's perilous. Lots of problems there. So a working knowledge of property law in your jurisdiction is at the very least useful. If you don't have it, make sure you run any agreements past your property or whoever it is you work with on conveyancing just to check it's not a problem. Right, so court can order property vested in one party or divvy it up. Can order the payment of lump sums, which is fine, and can order security for lump sums, so it can secure them on property, which is fine. Court can't order the sale of property, but in practice you can have a lump sum ordered which forces the sale of the property, as I understand it, or which makes it inevitable that that's what's going to happen. There are a few funny rules in there about real property, about hypothecs, which can, I assume the idea is to try and stop people from remortgaging or lending, having charges put against property during matrimonial proceedings, enabling people basically to enabling the court to look at the rights of competing creditors. Case of E and E, they were a very litigious couple, I think they crop up a few times, E and E. Wife wanted to refinance a mortgage. House had been changed into tenants in common. He wouldn't sign the mortgage. Got 3 orders from the court. He wouldn't sign them. Court ordered the transfer of the house into the sole name of the wife. That was overturned on appeal. So basically, the Viscount can be ordered to sign documents on behalf of naughty spouses, or whoever the equivalent of Viscount is in your jurisdiction. Sergeant, I think, is your equivalent of Viscount. So that would imply that banks do lend on joint tenancies in this jurisdiction. Sorry, on tenancies in common in this jurisdiction. But it is worth finding out a bit about that. SARC, I have gathered, is weird when it comes to real property, and the Guernsey Court has difficulty making orders over SARC property. Pensions, you've got nothing in your law in relation to pensions, nothing specific in your law about pensions. You could, if you wanted to and had the time, have a look at section 25 of the Matrimonial Causes Act of England 1973, which has a number of specific provisions in relation to pensions. Those are not part of the judge's toolkit in Guernsey, which means that the court just has to look at them in the pot and try and adjust things in as fair a way as it can. But it's very, very difficult to deal with pensions, especially you can get some pensions that are worth millions.
Also, they're liquid, aren't they? So if they are considered part of it, there is a huge delay in.
There is, we have fights in Jersey about whether pensions should be discounted and how much they should be discounted by if they're treated as capital assets for the purposes of working out an asset division, because they contain tax. People are going to have to pay tax on the income they get from those pensions. They're illiquid. Some of them are riskier than others. Some of them are nice, secured pensions. Some of them are not. And some of them are more generous than others. So you can get cases where actuaries are instructed to value pensions or to try and value pensions. And I think you've actually got specific provisions in your law about the instruction of experts and actuaries. Article 47 about maintenance. Now, maintenance is a bit tricky because there aren't that many rules about it. It's very much a case-specific thing. Generally, where it can, the court will avoid having long-term spousal maintenance payments, often by the making of a lump sum payment. So sometimes the court will come along and say, I'm going to give Mrs. X a lump sum payment of 2.5 million because this is going to generate a sufficient income for her that she will not need spousal maintenance and therefore can move forward independently. So lump sums are often used to avoid a requirement for ongoing spousal maintenance because it is seen as a bad thing. It stops people from getting on with their lives. It rankles with them. It creates a bad atmosphere, makes it harder to co-parent children. Nobody likes it. Women don't like having it. Men don't like paying it. And it's very insecure because if a bloke loses his job, dies, gets sick, whatever, women are in difficulty, particularly, for example, if they're using that money to pay a mortgage. Okay, so it can cause serious problems on both sides. So the court, when it's faced with a spousal maintenance claim, will look at whether there is enough capital floating about that it can achieve a deal which stops the wife from claiming spousal maintenance. In other words, can it give her enough without having to worry about ongoing payments? If it can't, the court has to work out how long maintenance is going to be paid for and how much it should give. Now, don't forget the court can award interim maintenance before a final hearing. That's short-term maintenance based on what people need. It's to get them through until the trial, basically. From a long-term point of view, the court's going to have to work out how long and how much. Okay? That changes over time as society changes. Back in the day, 20 or 30 years ago, it was not unusual to have orders that were made for a whole life spousal maintenance award, which means that the husband, whilst they're both alive, so a joint lives order, whilst they're both alive, the husband would pay maintenance for the remainder of their life. Okay? That was not unusual, particularly in long marriages where women have been out of the workplace for a long period of time. It was quite usual to have circumstances where wives would remain the responsibility of their husband for the rest of their life, unless they remarried. In England, remarrying is an automatic stop to spousal maintenance payments. It's in the statute. It is not in your statute. It is not there. It's not in Jersey's either. It's not there.
Let's really unfair.
So when you are drafting, make sure that your spousal maintenance comes to an end on remarriage.
Would you also put a period of cohabitation? What about if somebody?
We do in Guernsey. In Jersey certainly we will include as a trigger sometimes cohabitation. Normally after a period, it's normally at least 6 months, 6 months to a year. For the reason being that if it breaks down very quickly, it would be unfair to say, you know, you've lost all your chances because he moved in for a week or whatever. It's quite often a trigger in Jersey. It might trigger a stop of maintenance payments. I would say it's more common these days for it to trigger a review than a stop.
What cohabitation?
Yeah. Now, a review may mean it stops, but only if that's appropriate, because there is a chance that the wife will have formed a new relationship with someone who is not got any money.
But that's only if you draft it.
No, the court could make it a trigger. The court can do whatever it wants in terms of how long spousal maintenance is.
Why would we not have it as an automatic?
Because it can cause, because the reason that spousal maintenance stops on remarriage in England by law and in Channel Islands, because we're careful when we draft these things, but the truth is a court would stop that anyway, I think, is because a new person has come along and acquired responsibilities as a spouse. Cohabitation, no such responsibility. Okay, so if you remarry, you have been taken on by someone else, okay, legally. They have all the obligations under the law that a spouse has. Cohabitation, they have none of that. And there is a risk, and I think there have been cases where there has been a stoppage on cohabitation, the cohabitation hasn't lasted or something has gone horribly wrong, and not only the wife but also the children, if they are young, have been prejudiced by that stoppage. I'll give you an example. I had one where and luckily I acted for the husband. But there was a provision in the divorce which caused a stop on cohabitation. Spousal maintenance stopped on cohabitation after a relatively short period of time. So maintenance came to an end. The boyfriend then had a severe catastrophic accident skiing and suffered lifelong brain damage and required complete care. It was not a relationship in any real sense of the word, although she continued to take care of him as best she could, and he could make no financial contribution to her life. But her maintenance had gone. Now, had he been her spouse, she may have had some form of recourse or redress, but not against cohabiting. So if you're acting for women, be careful, if you're acting for the person who is receiving the maintenance, which is generally women, but not always, be careful of cohabitation being a complete stop. If you're acting for the paying party, you will want it to be a complete stop, and normally you reach compromise. And it depends just how weak the other how financially weak the other party is.
Because if you have a lump sum, that almost puts you in a slightly better position, because it's not going to stop anything because you've received it. Yeah.
A lump sum feels very unfair to men when the woman then remarries or cohabits within a short period of time. That does feel unfair. It does feel unfair. On the other hand, while spousal maintenance is in payment, you can always review it upwards as well as downwards. So what we have had are a number of cases of men who've divorced relatively young, in the earliest stages of their career, and have gone on to make a lot of money. Wife comes back, knocks on the door and says, actually, I'd like loads more money, please. I've spent everything you gave me and I'd like a massive uplift. And they've won. So a clean break benefits both parties in that men can get on with their lives and they're not constantly looking over their shoulder. And women can get on with their lives and remarry if they have an appropriate opportunity to do so. If it can be achieved, a clean break shouldn't be achieved at all costs.
Because it could be a clean break with maintenance periods, everything if you have an end point.
A clean break is only a clean break if there's no spousal maintenance. If there is spousal maintenance, it's not a clean break.
There could be children's maintenance if we...
You can never have a clean break from your children. Legally impossible.
Oh, okay.
You can never have a clean break from your children while they are children. Once they're adults, they're subject to inheritance law, you can do whatever you like, but you can't have a clean break from your kids. But your wife or your husband, you can. A clean break is just that. It means no more connection, no comeback. You can have a delayed clean break because you can have what we call term maintenance. And generally term maintenance is what you get now. And that is maintenance paid for a set number of years. The idea being to enable someone to give them time to adjust to independence without undue hardship is the wording that is used. Okay. Classically 5 or 10 years to allow someone to retrain and get themselves back into the employment market without being under undue pressure to do so. Okay.
What was the phrase?
Which phrase? Sorry, you get term maintenance.
Term maintenance, and that's for the fit period.
That's for a period of time. Now, that period of time can, in some circumstances, either be fixed or it can be extendable. So the court can say, we're going to give you maintenance for 10 years, but if despite all your best efforts, you've not been able to make a go of it, then you can come back and ask us for a bit longer or a bit more, but you are going to have to prove that you've done everything you possibly can. Those are called extendable orders, extendable term maintenance. And what English law now says, Jersey is certainly following down this road, I guess, to an extent. I don't know whether Guernsey will too. But what the English guidance is currently is, if the judge has got a choice between making a joint lives order and an extendable term order, they should opt for the extendable term order. Because actually what the law is about is paid maintenance to enable people to adjust to the future without undue hardship. It's not about enriching the end spouse. They shouldn't be able to sit back on their laurels and be kept women for the rest of their lives. That comes as a nasty surprise to a lot of lady clients. Okay. So joint lives orders are certainly now in Jersey rare, unless you've got a really, really, really long marriage and parties are getting on a bit and one party hasn't worked for a long period of time, but there isn't that much capital. You might use it to share a pension if there's another way of doing it, but they're not ideal. The amount, there is no formula for working out how much spousal maintenance should be. Part of the reason for that, unlike kids, part of the reason for that is it depends entirely on how much capital there is, because the more capital you have in life, the less income you need. That's just basic economics. If your house you can own mortgage free, you are not going to need as much money to live as someone who's got to service a mortgage. So if you've got loads of capital, your income needs will be less, even if there's not quite enough money to buy you out of your income and buy a clean break. So there might be not quite enough for a lump sum, but still enough to house you so that you are okay. And in those cases, you might have some spousal maintenance, but it's going to be less than it would be if you've been left with a massive great mortgage and 2 children. So it's all a relative term. And the way it was put to me by a barrister, actually one of the first barristers I worked with many, many years ago, was that it's a little bit like a rectangle. So capital income. The more you've got of this, the less you're going to need that. Because if you've got loads and loads and loads of capital, it may be that there's a clean break. Maybe you've got enough money. Because if you've got enough money, you don't need any spousal maintenance. You only need maintenance only covers what you need. It's not there to share people's income after their marriage or anything like that, because that stops when we get divorced. What we're talking about is people getting what they need after divorce. Okay, we're not in the business of sharing once you're divorced. Sometimes, if you share the capital appropriately, you can do away with the income altogether. They don't need it. Sometimes, 50% of the available capital will be enough to meet all their reasonable needs, and they don't need maintenance. And they don't need an extra lump sum, because their share of the matrimonial pot is enough. Sometimes they get an extra lump sum, and that means they don't need any income. Be careful of cases where you get a wife who is saying, I need a 50% of the capital, and I need another lump sum, and I need maintenance. Because those cases start to feel a little bit unfair. Is there any particular reason why you should be getting a lump sum if you know, an equal share of the assets if you don't get a clean break out of it? And sometimes people will try it on and not get very far with it. But yes, so we look at assets and we look at income and we're looking at what people need. Again, where there are spousal maintenance payments, they tend to be index linked, which is fine. Giving you a few cases about secured payments. I don't know how often they happen. They don't happen really in Jersey, but the fact that you've got a couple of cases on it would suggest that you see them a bit more than we do. We've talked about a clean break. We'll talk in a moment about how the court starts to look at the actual numbers. But these are the powers that the court has, we're looking at the moment. Settlement of wife's property, again, that Article 50 looked to me weird and antediluvian. It looked old. Settlement of wife's property, where a decree has been granted on a petition brought by a husband, the court may order settlement of her property for the benefit of children or the marriage or the husband. Now, I couldn't find that had been repealed. And it still shows in the consolidated text of the matrimonial causes law. But it looked weird to me. It's another one of those provisions that didn't look quite right in the modern world, but it still looks like it's sitting there. And Article 13, be aware that the court can vary financial orders. It can change them. Okay? It can vary or modify any order other than the order for the payment of a lump sum which has been fully complied with. Okay? It can also vary or modify orders made in different jurisdictions if the parties are both resident in the bailiwick, which is handy. Again, Guernsey follows English law in terms of the provisions it will apply, or the way, the principles it will apply when it's deciding whether to vary an order. Okay. When can a variation happen? Well, classically, because something's changed and you need to look at income. So you need to have a change to a spousal maintenance order or a child maintenance order. They can go down or they can go up. It is very difficult once you've got a final order to ask the court to change its mind. Very difficult. If a party has been guilty of non-disclosure in a really important way, you can sometimes get an order set aside. Even harder if it's an order by consent. A change in circumstances, something which in the UK might be called a Barder event, is very difficult to establish. Barder events are events where something catastrophic has happened, pretty much in the immediate aftermath of the final order. So something really dramatic has changed. But there is a case of Meyerson, which says that a dramatic drop in the value of investments, such that the wife ended up with more than 100% of the assets, I think was in that case, will not trigger a review of the capital provision. So you're talking about really, really mega big stuff. That is why it is so important to get it right, because you do not get two bites of the cherry in family cases. If you get the capital division wrong, you are pretty much stuffed. So it is important to get it right. Obviously, you can appeal decisions in the usual way, but the opportunities for changing your mind are minimal. And that's why clients require such careful advice when you are putting together settlements for them. Case of C&C, variation of a consent order after a judicial separation should not follow lines radically different by those from those taken by the parties in reaching their agreement. Their agreement is strong evidence that the terms were reasonable unless they were wrongly or mistakenly obtained. So again, the importance when you're looking at judicial separation by consent in particular, of making sure that actually the financial provision is going to be okay. F&F was an application to vary a maintenance order and set out a number of principles that the court would apply. Should consider falling income or increasing income, increase or decrease in responsibilities, including obligations to a new family. One thing that really upsets people is where an application is brought to bring maintenance down because husband has gone off and had a second family and can't afford the payments anymore. That, you know, is, and the courts disapprove of that, to be fair. We tend to say, look, first families, you knew what you were doing, but at the end of the day, the court has to live in the real world in terms of what people can afford to pay. So those are particularly tricky.
It doesn't cease upon the remarriage of the...
Not automatically under the law, as far as I could see. I wasn't able to find something which in that article which said that spousal provision ceases automatically in the remarriage of the receiving party, which is what the English law says. You don't have a clean break provision in your law. Specifically. None, we don't in Jersey. So statutory clean break provision. So how do we decide? Those are the toolkits. So that's what the judge can order. How does the judge decide what it orders? He or she orders, rather. So which powers it uses and how much it gives. And that really is, I suppose, the sting in the tail. That's the difficult bit. Because we can easily define whether judges have particular powers, whether and how they should exercise them is a different question. There are a couple of very useful documents floating about which you may or may not have seen. In England, there has been a lot of concern about how difficult it is, A, to act as a litigant person in your divorce, bearing in mind legal costs and the fact that there is now no legal aid for family matters in England generally, unless there's domestic violence. And how difficult it is for people to get uniform decisions out of the court, so how difficult it is to get consistent decisions. So there's been a lot of work done by the UK government on that, and the court's produced 2 sets of guidance notes on the way that the court divides up assets on divorce. One is for lay people, and one is for judges. Okay. It is quite a good idea to look at both of them. One of them gives you common sense advice as if you were a litigant in person, which is great for getting a grasp of the underlying concepts. Doesn't give you all the case law and everything else, but gives you a very good understanding, I think. And the other reminds judges about what the law is. So it's a very good statement of the law, including the case law.
Where will we find that?
I will put them on the alley for you. Okay, so they're very useful. But basically what it comes down to is that a judge has to decide what is fair. Okay. Now the problem with deciding what is fair is that noting people will agree what is fair. And your clients certainly will not agree that any of this is fair, by the way. Clients are never happy, whatever they get, with whatever they get in a contested case. And in fact, if your client is, if both sides are slightly unhappy, you know it's probably the right result. It's where one party's happy, you worry when you're doing. Right, so how does a judge go about dividing up assets? We remind ourselves what powers we have. We say, well, I could make this order, that order, and this order. You will know what orders the parties are asking for because you'll have been told by the lawyers appearing for them what it is they want. So you sit there as a judge and you think, well, how am I going to exercise my discretion? 2 really useful sources of guidance. The first is Section 25. Now, Section 25 is Section 25 of the Matrimonial Causes Act of 1973 in England. It is not Jersey legislation or Guernsey legislation, but both jurisdictions have adopted it through case law. So your case law says the court will have regard to Section 25 of the Matrimonial Causes Act. Okay, it's been amended a couple of times, but not massively so. The second is principles which are established through case law. Okay, and a few headline cases of that. There's not a massive amount of them, a few headline cases which set out principles that we apply when divvying up assets. Family law generally likes its checklists. Okay, it's something you'll see when we come to do children as well. One way of guiding judges in family cases as to which direction they go in is to take them through a logical process of checklist. When you're exercising discretion, it's quite handy. Section 25 is a checklist. Okay, it's a list of factors the court must have regard to when it is sorting out finances. The idea being that if a judge works through that checklist carefully, they will end up with a result that is human right compliant, meets the reasonable needs of the parties, and is generally fair. within the objection where that term can be used. It's quite long, and we'll have a look at what the Section 25 criteria, as they are known, are and what they mean. Now, Section 25 hasn't changed a lot since it first came in, which was many, many years ago. But the way that it is applied has changed through the use of case law and principles. Okay? So principles we had pre-2000. What judges were really looking at was reasonable needs. We're going to say we've got a spouse, poor spouse financially, husband's got all the money, wife needs to be okay. So we're going to redistribute wealth in a way that makes her okay, because we want it to be fair, and it wouldn't be fair not to be that way. In the year 2000, along comes Lady Hale and a few other people and says, no, we believe in equality now. We no longer discriminate between men and women. We say loud and clear, homemakers are as important as rainmakers, as breadwinners are, and we are going to treat them as equals. Okay. From that point in the year 2000 comes the idea of sharing. Okay. We share the fruits of the marriage. Okay. We are going to treat you as equals. That causes a problem where they're treating people as equals doesn't give them enough money. Is one case where it can cause a problem. So what the law says is reasonable need trumps everything. We make sure that people are okay before we worry about anything else. Fine. No great change there. It causes a problem where you've got a lot of assets that weren't built up during the marriage. So someone brought loads of assets in. Someone's inherited loads of assets during the marriage, or they separated actually 2 years ago, and following that someone's made a few gazillion quid. Okay. What do you do then? That's not fair. So the court since then has been preoccupied with what equality means and what exceptions we should make to equality. So we'll have a look at the two combined, Section 25 and the legal principles. Okay, let's start with Section 25 because that's the main checklist. It's been there for a very long period of time. And Section 25 is really about establishing what people have and what they need. Okay, in most cases, really start and finish there. Okay. Now, Guernsey, from what I can see, certainly has Section 25 and appears to follow English case principles, it appears to. Okay. So what does Section 25 tells us? It tells us that the court has regard to all the circumstances of the case. That's very helpful, whatever that means. But it goes on to say these things, certain things are particularly important when we think about what the relevant circumstances of the case may be. First consideration is given to children of the family, or sorry, children of the marriage, under the age of 18. And it is minors they're concerned with. They're not so worried about kids who are at university. Okay. First consideration. You need to just be mindful of the fact when you come to look at children that we use a different phrase then. When we're looking at the care of children and their lives, we say that children are the paramount consideration. Paramount means the first and only consideration in many ways. The test on finance is different. Children are the first consideration. That doesn't mean they're paramount, doesn't mean they're the only thing we think about, but it does mean that we make sure children are okay as a priority when divvying up assets. What's the court going to think about? Section 25A, financial resources. That's where financial disclosure comes in. It's about working out what the assets are and all the assets wherever they come from, no matter who owns them and no matter when they were generated.
Or where they're situated.
Or where they're situated. We're normally looking at worldwide assets. The court can sometimes look at assets which are held in company or trust structures. And the court expects to take into account assets you will acquire in the foreseeable future. Sometimes, yes. Sometimes. Or other benefits you know you're going to acquire. Classic example of that, husband has a business, isn't doing that well at the moment, but that's because he's bringing a project to fruition within the next 1 or 2 years, which is going to net him a number of millions in terms of what he personally will get out of that business as a capital sum. The court would not ignore the fact that he has that money coming, because he's probably built it up essentially during the marriage, but he's not yet received it. So a court will not ignore that that is a foreseeable lump of money that's coming in. But it can include inheritances, can. Doesn't always, can. It will look at what you earn. Your earning capacity is not just what you earn. So the court will look at what your earning capacity is now, but it will also look at what your earning capacity should be. So what steps you should take to acquire a better earning capacity. Okay, should you be getting a full-time job if you're a lady, and if not, why not? It's an interesting case around that. It asks itself under B, what are the reasonable needs of the parties? That's an important phrase. What are people's reasonable needs? Housing is generally the top one, but they may have other needs, may have a need for education, all kinds of bits and pieces, pensions, all kinds of things. Be aware of some of the interesting orders that a court can make in relation to properties to make people okay. And I talk in the study guide about measure orders and Martin orders. Measure orders are orders where a house stays, generally in joint names, often until the children reach a particular age when it's sold and divvied up. They tend to work very well for men. They do not work very well for the woman who's left in the home with the children, because inevitably when the house comes to be sold later on, the wife is left with a lump of money that's not quite enough to rehouse herself or do anything else with. And the husband has treated it as a pension or a savings policy and comes out of it very well, thank you very much. So they tend not to work out particularly well for women, but sometimes they're the only option. Martin orders can delay potentially until death, the realisation of the matrimonial home. You might have an order, I suppose, that the wife retains a home, but in a few years' time she pays a lump sum of X to her husband. You could do that, something called a chargeback, where there's a lump sum that the wife must pay, and of course if she can't pay, she then has to sell it, presumably, which is a way around the sale provision. But understand what different orders the court can make in Guernsey. The court has to look at the standard of living during the marriage. That's because reasonable needs are not equal. For most normal people, reasonable needs are being able to pay your rent or your mortgage, being able to eat, being warm enough, and having clothes on your back, and a generally okay standard of living. In a wealthy family, reasonable need goes well beyond that. I deal with maintenance orders that are worth hundreds of thousands of pounds every year, where people are living what is for them a normal standard of living. So reasonable needs does not mean subsistence needs. It depends on the standard of living that the family have had. Again, quite a subjective concept. So what does the court look at? For some reason, it tends to look at things like holidays. Did you have long exotic holidays? Kind of houses you've lived in, yeah, what you spend on clothes, non-essential items, if they're trying to get a handle on how posh in life you have had.
Would you be able to, in the trial, would you be able to sort of take the person through their expenditure or through their lives and say, you know, is this really a need?
Judges, there are cases, yeah, where the court has said, look, judges will take a big fat red pencil to women's budgets if they are overstated and unreasonable. There are sometimes budgets that women come up with during trials that are completely fictional, where they have never spent that kind of money, because what some lawyers advise and what some people believe is that if they put the highest possible figures in, they'll get more than they would do otherwise. So in other words, if they ask for loads, they'll get a little bit extra. Who knows, maybe it works sometimes. But you deal with that by cross-examining them on whether it's actually what they are even spending or have even spent historically. The other thing to bear in mind is that it's all very well to say, we always spent 20 grand each time we went on holiday. Now that may be true, but it could also be a fact that you were overspending even during the marriage. So there are a lot of cases, certainly I see in Jersey, where people have been spending more money than was reasonable. And it's often one of the reasons for the breakdown of the marriage. So presenting it as being a great standard of living is fine, but not if you were already living outside your means. You're not really going to get away with that one. Court has to take into account physical or mental disability. Do you have disability discrimination in Guernsey yet? Disability discrimination. We've only just got it in Jersey, but I would hope that you've got it, because that includes definitions of what a disability is. But if you have a client who comes to you saying, I've got a persistent mental health problem, for example, that's going to impact on my my ability to work, make sure you do mention it, and mention it at a fairly early stage, because you might need to prove it with medical reports and whatever. Contribution. Now, contributions has proven to be very difficult. It's part of Section 25, and it's given rise to all kinds of problems in case law, where one person says, I have made a bigger contribution than the other person to this marriage, and I should get more of the money. And we'll see that the legal principles that have evolved through case law, that is still very much a problem, and is being litigated regularly with more money cases. But we know now that homemakers and breadwinners are treated as equals. That is a yardstick of equality, as the case of White and White calls it. What it doesn't mean is that we divide stuff down the middle, and a lot of lawyers, for reasons I don't quite understand, approach cases on the basis that we automatically chop stuff down the middle. Now, that may be true in some cases. That may be what equality looks like. But in a lot of cases, actually, in fact, probably the majority, you do not end up with a straight 50-50 split. Because to treat people as equals does not mean you necessarily divide stuff down the middle. And I'll give you a picture example of that. Ignore that little one there. Okay. Let's say this is Dad, and let's say this is Mum, and we want to put them on a level playing field. So what Mum is going to need is a step to standard, additional support to make her equal, okay? To give her an equal ability to buy a house. So, for example, a husband who has a borrowing capacity for a mortgage of £500,000 isn't going to need a massive deposit. Okay, he might even just need the minimum deposit in order to be able to buy a house and service a mortgage. If the wife's going to have an equivalent property of £500,000 living with the kids, she's going to need a much bigger deposit, because she will not have the borrowing capacity unless he gives it to her through spousal maintenance. Okay. So equality isn't about just dividing the assets down the middle. It's trying to put people in an equal position and treat them as if they are equals. One of the confusing things about some of the case law is that they do talk about equality, and literally cutting stuff down the middle, sharing principle. That really only works in cases where there is an awful lot of money, so much money that dividing it down the middle makes sure that everyone is more than okay. And those are a tiny, tiny minority of family cases, tiny, where there is so much money that dividing it down the middle equates to equality, actually. Okay. So, husband in that case is going to be saying, but I've made a bigger contribution. He might be saying, I brought the first million into the marriage. And we'll have a look at how that's been dealt with in case law. The contribution is something that we have to have a look at. The next thing is conduct, and conduct is the flip side of contribution. Section 25G. What the law says is that the court must take into account conduct which it would be inequitable to disregard. Okay. That means really, 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 really bad, basically. Or hen's teeth rare, attempted murder, really serious conduct, generally which has had a clear financial impact. It includes, for example, things like what we call wanton dissipation of assets. So husband who has a moderate amount of money, but not, not money to burn, goes out and buys a Ferrari and then crashes it into a wall. Okay, there was actually a case about that. Crashes it into a wall deliberately to waste money so his wife can't have it. Happens. I wish I had £1 for every client who had said to me, I'd rather you had my money than my wife.
Wasn't there a case where a woman sold a car, like a Jaguar or something, that's worth about £20,000 for £5?
Yeah, again, that would probably be financial conduct. It's trying to put assets beyond the reach of the court, really. Giving your jewels to your mum, whatever. All those kind of things are likely to be things the court will frown at. But where there's not a direct financial consequence, that's because that's almost litigation conduct, that kind of thing. Where it's just behaviour, he behaves so badly, or she behaves so badly, you have to have something really, really, really so serious that you are unlikely to ever see it in practice. I have run, against my will, I have to say, 2 conduct cases, I think, in my career, and I've lost both of them. And that was probably the right decision. They are really, really rare true conduct cases. The ones where I did have a good point, it's been settled because they had to accept, yeah, right, that's we really shouldn't have done that. I had one case where a husband bought his girlfriend out of prostitution in a foreign country, for example, and used family assets to do it. Bought his girlfriend out of prostitution using family assets, and he had to give that back. But it's things like that are fairly quite obvious. And I agreed. Loss of benefits, the court has to take into account 25H. Quite often that's pensions, can include things like inheritances. Some people are effectively kept by their parents even as adults, and that can be a relevant factor if you've lost your anticipated inheritance from someone who was realistically like to pop their clogs within a relatively short period of time. Loss of a pension, loss of the ability to benefit from a discretionary trust because you're no longer the spouse of the settlor or the spousal beneficiary. Be careful of those provisions. Those automatic provisions where we put in spouses or in trust deeds. Very common, and then they get divorced and they didn't realise that their spouse was a beneficiary. So not ideal. Okay, and I mentioned a few Guernsey orders there. E&E, where you had a wealthy husband, wife had no money. There was a prenuptial agreement, so that's quite interesting to see how we deal with prenuptial agreements. She signed the agreement without legal advice. Marriage failed, but it was a short marriage. factor that the court has to take into account is the age, and this is section 25D, age and length of the marriage. Okay, 5 years is short, whichever way you look at it. Even saying, didn't uphold the agreement but didn't ignore it, and that's quite common with prenups. The court gives it some weight, but the amount of weight varies. Enabled her to escape off to England. Court will generally uphold properly negotiated agreements. So all quite useful stuff when looking at the importance of prenups.
What happens with that case?
I think they gave her enough money to relocate, really. She certainly wouldn't have got, you wouldn't expect after 5 years to get a massive, you'd expect your needs perhaps to be, if not met, then at least given a good start onto meeting your needs. I think she was quite a lot younger than him as well. But you wouldn't expect to share, certainly, after 5 years. Length of marriage becomes quite important. I versus I, that's your case which says we apply the section 25 criteria. Cites will approve on the case of White and White, which is the case in England from which all other cases spring, really. Talks about pensions, they have to be considered. Housing is the most important consideration. Court didn't like the idea particularly of nuptial orders. I don't like them either. C and C, 2005, an accountant. Her wife was a nurse. Again, a 5-year marriage. They'd run up lots of debt. Husband had been able to pay his off or pay them down. The wife hadn't been able to pay hers down. No capital assets. You do get some cases where there is nothing but debt, and you're actually looking at how you divvy that up, really. The wife asked for a lump sum or maintenance. Court held under Article 46. The court couldn't redistribute debt between the spouses. In 2007 or 8, there was another decision which expressed some doubt about that. I think actually that's right. The reason the court can't really redistribute debt is why.
Sorry.
If you've got debts you owe to a third party, why is it probably inappropriate for the court to redistribute those debts to say who's liable? Let's say you've got a joint debt for an overdraft. Why isn't it okay for the court to say, you husband, you must pay off that joint overdraft in a court order? Exactly, it's the third party obligation. So what governs liability for that debt is the agreement with the bank. So if the bank is saying you're jointly and severally liable for this debt, the court can't, without the bank being a party, reorganise that. All it can say is it can take an undertaking from one party that they will be responsible for payment of half of it. Or they can say, husband, you must give wife at least X pounds per month so that she can discharge this debt. So there are ways of doing it, but you can't make an order which affects a third party lender. I wouldn't have thought. I think that's probably right, but you can't do that. Yes, under Article 47, the court is able to include payments to assist the spouse to pay debts, and those payments might be made direct to a creditor. So you could order a husband to make a payment to a creditor. That's fine, but you can't order the creditor to accept that payment to satisfaction of the debt, because that's not up to you. D&D, a classic case of something changing. Property was going to be transferred and the lump sum was going to be paid to the other party. Got a consent order drawn up. Wife then had a problem obtaining finance for the lump sum because the valuation was lower than had been expected. Okay, so exactly the kind of problem that does crop up. She couldn't get a loan, so she wanted to sell it instead. Husband tried to enforce their agreement, and he said no. Actually, I'm going to enforce it. I quite like the deal that I had. No doubt because the valuation of the house had gone down. So he was doing rather well. He brought the point as a preliminary issue, said, court, I want you to make an order in terms of the consent order, even though it's never signed. The court said, we can't do that. You had reached an agreement, but we can't approve your agreement because you're divorced. We could have approved it had you been still married, but we can't now that you are divorced. We could make an order in the same terms if we wanted to, but we'd have to consider all of the circumstances of the case and apply Section 25. Here, it would be unfair to make an order where the wife wasn't able to obtain finance. I suspect what the husband was after was the wife having to sell a house and pay him a larger lump sum, and him ending up with actually far more equity than he should. That would be unfair. The court considered, and it's horrible for lawyers when this happens, evidence of the negotiations. So the court had to look at the without prejudice and other correspondence between the parties to try and work out whether an agreement had been reached, as it did in the case of Zidias in England, which the court cited with approval. Costs. Costs can follow the event. So if a party wins, they may get their costs. It's often easy to win as such a case, but that can be easily displaced. If you make an open offer and that's rejected, then you are certainly at risk of costs. In cases concerning children, it's unusual to remove costs, and we're pretty much in the same position as in Jersey. D versus D was arguments over houses, the home and the contents vested in the wife, and there was a charge back to the husband. So the husband was at some stage going to pay her £90,000 on her death, remarriage, or cohabitation, or if she sold. Okay, so classic Martin order, I suppose. Open-ended spousal maintenance because of her medical condition, so her disability. The husband appealed. Court of Appeal held. Court will only rarely interfere with the judge's exercise of discretion. Okay, so where you've gone plainly wrong. Quite hard to appeal ancillary cases because it's quite hard to show that you are plainly wrong. The Court of Appeal declined to vary the order in relation to spousal maintenance, so they said go away. In relation to the property, they did decide that the Royal Court hadn't given proper consideration to the Martin case. The husband did have a need for housing. In other words, they've given too much priority to housing the wife. He should have been able to buy, and the Martin order was unfair in the circumstances of the case. The court really just ordered her to pay off that charge within a shorter period of time. The moral of this story being, courts have to remember to be fair to both parties. And it's probably not fair to keep one of them off the housing ladder for any longer than is necessary if there is another way of doing it. And again, the court went back to white and white. The numerous cases of E&D who seem to have the divorce from hell, I don't know who acted for them, but I bet it's horrible. And this was basically a husband who wouldn't play ball. Can get over it if you like. Matrimonial home was the only asset.
There's only net equity of 200,000.
Yeah, that's not uncommon to have for that to be the sole asset.
There's just a bit down the line, there's sort of litigious nature of it.
They just, when a party cannot get their head around the divorce itself, and it all feels horribly unfair, there's an old saying in mediation that people fall in love with their disputes. And sometimes they will come back to court and come back to court and come back to court long after they stop winning because they cannot let it go. And that appears to have been the case here. So this was a litigant who just refused to live with the orders that the court was making. And probably cost his wife, I would guess, close to the £200,000 they were arguing about. It can't have been much less than that. I don't know, it can't have been. So the wife didn't want spousal maintenance. She had day-to-day care of the children, and they had an awful relationship. The court vested the house in the wife, gave the husband £100,000 charge, payable when the youngest child reached adulthood. The Court of Appeal varied the orders to some extent. They said equality was the correct approach. He'd made an equal contribution in the equity as a result of their joint efforts. Split ownership was appropriate. The wife would have a usufruct, which is an interesting use of Guernsey law. Basically, they gave the wife the ability to occupy, so sole occupation of the home with the children until a given trigger event. She'd get the income from the lodgers, and she'd have the responsibility to upkeep the house. The court could then divide the property up at a later date. He'd be able to claim his share when the younger child finished full-time education. She could sell up whenever she wanted. Now, you would have thought that the husband might be quite happy with that appeal judgment because they were trying to be fair to him. He then refused to execute documents to change the mortgage. Court said, okay, let's put the house into the name of the wife. Court of Appeal again said, no, that's not fair to the husband, but said the sergeant should execute the mortgage documents to enable her to remortgage the property. He was just being spiteful. He then tried to go to the from the Court of Appeal to the Privy Council, which is bonkers, and they said his complaints are that he has been disadvantaged by inadequate and malevolent counsel and unperceptive or malevolent judges. There is no point of law involved. He is unfortunately unable to reconcile himself to the consequences of his divorce. Too protracted. The applicant does not excite sympathy because of earlier non-compliance with court orders or refused leave to appeal.
The council wasn't.
It will be on the case report. I didn't look, but it will be on the case report. It's quite a while ago. They may or may not still be around. He may even have been a litigant person by the time he got to the application to the council. But yeah, you do get couples who will just not let it go, and no award is ever good enough. Because actually, what they're looking for is retribution. They're not looking for fairness. Be careful of acting for people like that. You will never satisfy them. They're insatiable. And you do eventually become the target of their hatred for their spouse. R&R, wife's application. As far as I can see, virtually all your case law is to do with matrimonial homes, which is interesting. Again, regard to be had to the section 25, and equality, basically, the husband being entitled to 50% of the home. Wife and the husband is about costs, and does say that the court may look to the family procedure rules for guidance on costs, which is quite useful. I wish the Jersey case would have much guidance on costs. A versus B. Spousal maintenance paid under a court order will not cease to be payable automatically following the remarriage of the payee, the receiving party, but there is a presumption that payments will stop. But that presumption can be rebutted. Yes, that is different to the UK. Right. Does anyone need a 5-minute break before we have a look at English case law? Go for it. Okay, so English case law. I've given you a little Reader's Digest of English case law on pages 72 to 74. And the reason I've done that is to give you a sort of easy checklist of what some of the main, what I think some of the most interesting English cases are family law in England is specialist subject. So there are areas where if particular issues crop up, you will have to do a lot more research on them, but it's quite difficult to identify them at this stage in your learning, or rather for the purposes of exams really. But there's certainly a lot of reading around that you can do in particular areas. White and White, as I've said, was really the turning point. It's difficult to pay too much attention normally to cases that predate White and White because it was such a fundamental shift in the law to introduce that concept of equality. And that concept of equality has led to massive changes in the awards given to, in particular, wives in Britain. That was followed relatively quickly, within 5 years or so, by the case of Miller and Miller and Macfarlane and Macfarlane. Now, the reason there are 4 names there is because it was a combined appeal. So the court was considering both cases at the same time. House of Lords case is worth a read. The case of White and White is actually very short and doesn't lay down as much in terms of principle as we like to think back to it having done, because although it was the starting point, it's really the case of Macfarlane or Miller, whichever way you want to put it, that puts a lot of flesh on the bones of what we meant in White and White. So in some ways that's academically the more useful case. And what Macfarlane said was that fairness is an elusive concept. I agree, that's the problem with family law. And it has 3 strands, said the House of Lords: needs, compensation, and sharing. Okay. So first of all, we look at what people need to be okay. Then we look at compensating them for perhaps any hardship that they've suffered because they have given up their career. That kind of stuff. Sharing means that we share the fruits of the matrimonial partnership. So in other words, if you have a very, very rich husband who's kept all of the assets in his name, but all of those assets were built up during the marriage, a judge is likely to come along and say, well, the wife has the ability to share in those assets. And in that case, you might well get an equal division. Everyone's needs are going to be met. She's going to be fairly compensated because she's getting a large amount of money and she's sharing the assets of the marriage. And that's where 50-50 divisions really come from, is from the principle of sharing. Okay. Most cases don't get any further than needs, something like 90% of them. We spend our time actually working out what people need, and you get nowhere near the sharing principle. It may be that a wife needs 95% or 100% of the assets to be okay. All depends on what assets are available and on all the circumstances of the case. But we go back to that little picture. The wife in that case needs more than 50% of the assets because the husband isn't so wealthy that an equal sharing is going to give her enough. She needs more money than he does in order to get on the housing ladder, for example. Most cases are like that. Okay. The ultimate objective, said Baroness Hale, is to give each party an equal start on the road to independent living. So that's what we mean by equality. We mean giving people an equal start. And it was in Macfarlane that judges started saying spousal maintenance should be awarded for a fixed term if possible, so not for joint lives, if it's fair to do that. So judges starting to cast doubt, this is the flip side of not being discriminatory. Actually, we'll only give joint lives orders where people really need them. And it may be that 5-10 years is enough for you to adjust to independent living. Because that's what equality means. There's a good thing about it and a bad thing about it. And it clearly established that adultery is not conduct. Okay, having sex with someone outside of marriage is not behaviour which it would be inequitable to disregard. that comes as a really nasty shock to most clients whose husband has run off with someone else.
Once again, they're not being punished in any way.
They're not being punished for
example,
breaching their marriage contract. They're not suffering enough. And it also comes as a nasty shock to some people that they can't claim financial support from the other party as well. Every now and again, I've had a case where someone has left for another partner, and the other partner has had money, serious money, and it's come as a shock to the client that they can't make some kind of financial claim against the party that the other person's run off with. They have no obligation to meet the needs of their boyfriend, girlfriend's family. But adultery is certainly not conduct which it would be inequitable to disregard. We also, in Macfarlane, see the importance of looking at the length of the marriage. One of the cases that was involved there was a short marriage. Lots of assets, short marriage, no children. And the court said that's important, that makes a difference. We are less likely to say that you should share in a large pot of money if your marriage has been short. The case of White and White was a very long marriage. One of these cases was a short marriage. I think it was a 3 or 4 year marriage, something like that. The court said that's short and that's important. So a wife in those circumstances is not going to share in marital assets or in the assets. Then comes along the case of Sharman. Some people like Sharman, some people don't. The court should start with equal sharing and only depart from that where it's necessary to meet needs or for another good reason. So we start from the expectation, and again really only applies in big money cases, that we're going to cut things reasonably squarely down the middle unless we need to do otherwise to meet needs, which in 90% of cases you will, or where there is some other good reason. And people have been litigating ever since over what we mean by some other good reason. What reason is there to depart from equality or an equal division? When looking at whether property is family property, so whether we should be sharing equally as family property, the length of the marriage is important. If you bring £100,000 into your marriage and you are then married for 30 years, the fact that you brought in that £100,000 at the beginning is likely to be irrelevant. If you bring in £100,000 and your marriage lasts a year, it's going to be very relevant that you brought in £100,000. That's basically what the court was saying. Sharman also said, I had a word or two to say about trusts, and there are a number of Sharman cases. It also talked about exceptional contributions. It said, in some cases, one party makes an exceptional contribution, special or stellar contribution to the assets. Okay. Now, we've been arguing about that ever since and what that means. What is a special contribution? How is one party more equal than the other? And how does that sit with discrimination? Because in most stellar contribution cases, you're automatically discriminating against the wife if you say the husband has made a stellar contribution because she had no opportunity to match that contribution because she was at home caring for the children. And how come his contribution is stellar, but hers in caring for the children is not? A world of pain and a lot of case law around stellar contribution. Length of the marriage, for example, and stellar contribution was considered in the McCartney case. Okay, Paul McCartney got divorced from his wife. Judge did not like his wife at all. It's a hilarious judgment. It's very funny to read. It's quite long, but it's a good judgment to read. Did not like her at all. Did not like Helen Mills. But important things in that case were that this man was truly a genius, and it was a very, very short marriage. There was a child, but it was a very, very short marriage. That's worth a quick read, but not really a case that sets out much in terms of principle anymore, I suppose. Case of Jones. Generally, we're talking about what's available to meet needs. All assets are available to meet needs wherever they come from. If a husband has inherited £1 million during the marriage, but the actual marital assets are very small, perhaps the couple between them have only built up £100,000, that inheritance is going to be fair game if it's needed to house the wife or family. Okay. If there's more than enough to go around, so if needs are met, the court will look at where assets come from. And there's also a lot of case law on what are family or non-family assets. Okay. How do we treat inherited assets? Does it matter if they've been retained in species? So if I inherit a manor house in Norfolk, which has been in my family since the 16th century, is that in a different category to me having just inherited £1 million, which I've stuck against the mortgage in the matrimonial fund? Is there a difference between the two? The law says there probably is a difference between the two. Okay. What if I bring a lot of money into the marriage? What if I gain a lot of money after the separation or after the divorce but before the final hearing? And sometimes people can come into millions within that short period of time. How is that money going to get treated? Run of cases dealing with large bonuses that have been received or business sales that have happened shortly after a separation or divorce. SS and NS. Some people think this is where the tide started to turn a little bit against, not against women, but back in favour of a more balanced approach in terms of breadwinners and spousal maintenance. I had a client who would have been around this time complained bitterly that he was effectively being asked to keep his Harvey Nicks wife for life, because these are cases where there's so much money. Kids were all at boarding school, so she wasn't really being a mum for very much of the time. They were teenagers. When they were around, they were spending as much time with him as they were with her. She didn't work, didn't do anything, and she went shopping every day. That's what she did. And he was maintaining her with hundreds of thousands of pounds of maintenance every year to go shopping and, as he put it, lunch. He thought that was really unfair. She wasn't particularly old, but he was, in to all intents and purposes, he thought of himself as being a meal ticket. Okay. It was difficult to argue with him on that, to be honest. So we have a little run of cases like SS and NS which came along. An award is properly made where the marriage has generated hard future needs. The length of the marriage and the presence of children are pivotal. If you have a very short marriage, you are going to find it hard these days to get spousal maintenance. If you have no children, you are going to find it quite hard to get spousal maintenance.
Is that because they think that your lives aren't sufficiently intermarriage yet? If you've got a short divorce?
Yeah, a short, I think the idea is there is a limit to how much you could have reasonably come to rely upon the assistance of the other party if you've been married for a very short period of time. And actually it does, I think, feel unfair where women enter marriages with wealthy men a very short time later, turn around and say they're leaving, and then want maintenance as if they've maintained that lifestyle for 30 years and wanted it for the rest of their lives. Because by definition, they've only had that lifestyle for a limited period of time. Is that different if there is a very long period of cohabitation? I don't know. The jury's out on that one. If you've had a very long period of cohabitation, that might be relevant.
That's difficult because cohabitation doesn't carry any benefits.
No, and there is clear authority saying it might be relevant, but it is not the same as marriage. It doesn't require the same commitment. Okay. Presence of children is important. You can have a very short marriage, but a child, and that can generate the kind of needs where you need some spousal maintenance at least for a period of time. other than in exceptional cases, an award is limited to needs. There had been a small run of cases before then where the court had sort of almost looked like it was sharing a husband's future income. And the judge said, no, 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 we draw a line on divorce. You're no longer playing your part of this marriage, Mrs. So-and-so. So actually, in terms of ongoing financial provision, we're looking at what you need. You're not looking at sharing the fruits of the marriage partnership because the marriage partnership is over. You are limited to what you need. The purpose of it is to alleviate hardship to a degree. This is about enabling women to transition into independent living without undue hardship, by implication meaning a bit of hardship is okay.
I guess if they don't work and then they've got to be reintroduced.
Yeah, working is not considered undue hardship. It's basically, I think, what the judge meant. I think this was Nick Austin again. It's quite, as I say, it's well worth a read this case. Court must consider a termination of payments as soon as is just and reasonable. A term should be considered, that's a fixed period, if it will be enough to allow them to adjust without undue hardship to the ending of those payments. In a finely balanced case, the court should make an extendable term order rather than a joint arms order. So that's that term which can then be extended if that has to. The standard of living is relevant but not decisive. The objective is for them to be independent. Okay, so quite, you know, not the most lady-friendly judgment in the world. And not everybody was a massive fan of it. So, Right and Right was a case where a lady was basically told, I think by a lady judge, to go and get a job. And she had a child, I think, who was 7. And the court said, there are lots of working opportunities out there for women, children of your age. Go and get a job. Was basically what she was told. Preston Petradell. Again, a whole run of cases relating to trusts. I haven't gone into them in massive detail here. Charman is one of them. Parties hiding behind trusts again struggle. Preston Petradell was about a rather unpleasant gentleman or tricksy gentleman who had all of his assets in a company, and there was a dispute over the extent to which he was the controller or owner of that company. And the question was whether the court could make orders against those companies for the transfer of assets. That's fine. Quite a complicated case. What the judgment effectively said was that they found a workaround in that decision, but the court has to be very careful when making orders against companies when trying to pierce the corporate veil, unless they are very sure of what they are doing in terms of being able to enforce those orders. And again, there's the issue of whether, in fact, shares in a company are being held on trust for a party. You're likely to come across this quite a lot in the Channel Islands, where people quite often keep all their assets in companies. So it can be a bit of an issue, and there sometimes there's no easy answer. It is quite possible to be very wealthy and appear to own nothing, and yet to be living an amazing lifestyle. And some care is required there. McCartney, the needs of the wealthy are higher than the needs of the less affluent, which, yeah, that's true. Age versus age conduct case about attempted murder. Not much amounts to that. Again, there's a whole run of cases on conduct, and we tend to differentiate between behaviour conduct, which is hitting people or attempted murder or running murder or whatever, and conduct which has a real financial element. Radmacher prenuptial agreements. This was expected to be a landmark case in relation to the enforceability of prenuptial agreements. And having waited for Radmacher for a long time and then read it, and it was painfully long and boring, I wasn't entirely sure to what extent it had changed the law, but it did change an emphasis in the sense that the court will uphold a nuptial agreement if it's fair to do so. So they are not binding and enforceable, but they can be important and in some cases can be of magnetic importance. Parties may be held to them provided it's reasonably fair, even if they amount to less than the order a court would have made under law. So there is nothing wrong with you agreeing the terms of a prenuptial agreement which is less generous than a court would be after a contested hearing. Nothing wrong with that at all. There have then been a number of cases that have followed. The most useful one I find is the case of Luckwell, which goes through what are good things and bad things about prenuptial agreements and what parties should consider doing if they're thinking of entering into a prenuptial agreement. In the case of Radmacher, it is widely thought that it might have been decided differently had it not been the husband who was making the application. This was a case where all of the wealth was with the wife. The husband had given up a very lucrative career in order to marry her. He had signed the agreement in a language that was not his first language, I think without legal advice, the day before the wedding. Okay. And although the agreement was varied to a degree, he was basically held to what was a prenuptial agreement that was less fair than the court would have ordered. There have been a number of other cases, and the government has looked at circumstances in which prenup should be upheld. Generally, you should try and do them at least a month before the wedding, to give people a cooling off period. There should be financial disclosure. There should be legal advice. And independent legal advice, which the richer parties should pay for. And they should, to the best of your ability, be reasonably fair to the extent that they meet the reasonable needs of the other party. Because if they don't, the chances are they'll get thrown out anyway. What advice do you give someone who's being asked to sign a prenup? Generally, the advice I give is don't. Because the purpose of a prenup is to limit your claims. The reason someone is asking you to sign this document is because they think you could get more out of a court. Now, very occasionally, prenups work in the favour of the poorer party. Some prenups are front-loaded. In other words, you get a nice juicy payment after a relatively short period of marriage, and they work out great after a short marriage, particularly with no children. But the whole idea of a prenup is to limit the claims that can be brought by the poorer party. So it is not often going to be in your client's best interest to sign them. Having said that, they're quite often not being given a chance. They're being told they won't get married if they don't sign it.
Yeah. But then can you really say that you've entered into it freely?
Well, I always wonder why that doesn't amount to duress, but a lot of prenups specifically say, I understand he would not, I hereby say I understand he would not have married me apart from my agreement to enter into this commitment.
Would be duress during marriage?
I don't think you really need to a contract. The duress to invalidate a contract doesn't require you being married. So I don't know, but part of the consideration for entering into it is the fact that you want to be married, perhaps.
I guess you should enter into a marriage assuming this is not going to end. It doesn't matter if you sign it because...
Yeah, although, and certainly that would be, the prenups I've done that have worked well have been for actually people who were not British. I have done one with a Canadian lady, which was brilliant, but then they routinely do prenups. It's what they expect. It's sort of almost automatic for them. But British prenups are very difficult. And you need to be very, very careful because it's quite easy to be, if not negligent, to run into difficulties very easy. Whichever party you're acting for, actually, because you are trying to predict the future. You're trying to predict how long they'll be married for, whether there'll be any children, and whether it will look fair or not.
Is that a situation where you get both parties coming in together?
I would never try, I'd never talk to both parties at the same time about prenup. It's very important they have separate advice. Tax. Contact the income tax department if you're not sure what the impact of the separation is going to be on your particular client, or the client will have to. And they have to confirm their separation, and then I think they get new tax notices, and then separately taxed. You get some allowances that people might argue about.
We have obviously pension is different depending if you're a spouse or a single person. So that.
Yeah, will be, and child allowances. You're bound to get child allowances as well. Housing, I get the impression it's not as much of an issue here as it is in Jersey. But if your right to live in Guernsey is based on your relationship with a qualified resident, that's going to be a problem.
It might be a situation where if you've got a separation by consent, which is for 2 years, let's say you haven't met the 8-year threshold on the old one, 10 year on the new one, you might have to eke it out.
Yeah. I have certainly had to be careful about when I've obtained decree absolute in a couple of cases, because a client's housing status depended on not being divorced before a given date. It's even more important, it's not just housing qualifications for, say, classically British people or whatever who are living in the islands, where you've got someone who has needed a proper immigration visa, so someone from America or Australia or whatever, who's moved with either a local or a licensed spouse. Following divorce can have a profound effect on their ability to stay. And where you've got kids, that's a real problem. I've had a number of cases where the other party has been from Australia, wherever, and their ability to stick around is quite tricky. In terms of housing qualifications. Right, so we've got 20 minutes to have a look at Barbara and Adam. We've already advised Barbara on divorce, so now we're sorting out her money, because that's classically what happens. The thing to remember about ancillary relief questions is they can look quite long and quite detailed. Again, don't panic, just work through them methodically. How do you think you would approach this question?
They didn't have a very long marriage, did they?
No.
For Adam, but Adam has paid the deposit on the house, so then that might impact.
And the 50,000 was inherited from his grandparents. So he's brought in, not only did he pay the deposit, but it's an inherited asset. It's not money he built up during their relationship or anything like that.
But if there is inheritance, it can be used if it's to want that housing for both parties.
Yeah. Yeah, I mean, what you're going to do, if you're answering this question, is you're going to look at all of the, probably each of the section 25 criteria and work out which is relevant to this case is probably a good starting point, having in mind at the back of your head the toolkit that the judge has. So you're going to think, okay, they've got a property, he paid the deposit, there's only, what, 150,000 of equity in it. The mortgage has got a really good interest rate and payments are significantly lower than rent would be. Barbara says the home is her refuge and she cannot contemplate selling it. Okay. No, but it can create an order which brings about that. It's not what she wants. I mean, certainly if parties agree to sell it, I dare say the court lets them do so. Can't stop them from selling it. Then it becomes a matter of how you divide up the money, isn't it? Got 5 grand in the bank account. He's got £100,000 pension. There's a bit of debt. Okay. So in terms of section 25, you're going to start by looking at what the assets are.
You've got the house, the joint bank account, the pension.
Yep.
She has a car. We don't know if he has a car. And Adam's income.
How old is Charlie?
Charlie's a baby, isn't he?
Oh, yes.
Dominic's older, but Charlie's about 30 years old.
But
He might be starting nursery.
of their assets, £100,000 is a liquid in the bedroom, plus 150 equities in the house. So they don't have that bigger pot.
No.
Plus they've then got the £10,000 debt, although it's in her name.
So in terms of assets, they are not rolling in money. So do you think this is likely to be a needs case or a sharing case? You're going to be looking at achieving a solution which meets their needs. There's nowhere near enough to start to worry about whether this is a sharing case.
Because it's only
There's no money.
There
is no money.
And the children are supposed to start protocol.
Yeah, which classically, because they do this very annoyingly, she's put them down for whether they can afford it or not, and without enough consent. Or without his having agreed to pay the fees at least.
But their expenditure is £5,000 a month. And if you put that over a year, that doesn't mean I have a lot of this £70,000 income, does it?
She can earn about 30,000 a year for herself, don't forget, so that would come off. Yeah.
But she hasn't worked, has she? So she needs to not have undue hardship before she gets back into the
She doesn't want to work at all until Charlie is secondary school age, which is a long time.
Is that reasonable though?
A lot of these cases are about managing expectations, because a lot of people have no real understanding of how money works. So they will, well, he's got to maintain me. He's got to put a roof over my head, and it's not fair on my son that I work until he's at secondary school, because my friends don't work until their children are at secondary school. And you will say, but there isn't really the money for him to be able to afford that. Well, but I've got to be a mum. That's the priority, is me being a mum. And they cannot somehow compute the fact that there just isn't enough money to make that qualitative decision. It just isn't there. So you're going to be looking at how you divide up the assets and what orders you make in relation to assets. you're going to be looking at child maintenance and school fees, and you're going to be looking at spousal maintenance, whether any spousal maintenance should be paid, and if so, for how long. And the way to achieve that is to, if you like, draw a ring around in your head the factual elements of this that are relevant to those Section 25 criteria, and then check principles in the law.
So in your experience, what would happen? What would be typical?
It would be a matter of doing the best that you can. I mean, in Jersey, we might conclude there just isn't enough money there for either of them to be able to buy a house. So we might expect them to rent. But the problem you've got is that at the moment the home is very good value for money, because it provides a cheaper home than renting would. So I would probably try to find a way to retain the house for at least a period of time, and then think about who's going to make the mortgage repayments, just because I'm not sure it works in either party's best interest to sell it now, even if the court could order its sale, because it's a cheap, cost-effective way of housing a family.
Because even if you could get it to 200 of equity, you then have enough for deposit, and the mortgage would be huge on a £30,000 salary, would it?
Even if you could retain it for 5-10 years or whatever, at which point she pays him a lump sum, and you know, either she takes the house or she doesn't, or whatever, then at least it gives them a fighting chance to build up a little bit of equity. But I think they should both share in an interest in that equity. I don't think it should all go to her. Nor would I say that his £50,000 is going to be given a lot of attention, unfortunately, because I think there's just not enough money for it to be of massive relevance, I don't think. And because of his pension. So yes, he might have brought 50,000 in, but he's also got a pension that's worth 100,000, and they might sort of come out in the wash, actually. Because you wouldn't say that in a division, pension should have a capital value. We wouldn't treat it like £100,000 worth of cash, because it's not. But you can't ignore the fact it's got it. So there has to be some adjustment of the assets to take into account the fact that that is there.
Could you then say that she will come off as a beneficiary of the pension if she got slightly more favourable housing needs?
Well, she's not a beneficiary of the pension. It's his asset, he's got to keep it. You can't pension share, you can't do anything with it. Post divorce, she has no interest in that at all. None. So the question is, how does the court adjust the other assets to fairly reflect the fact that he has a pension with that money? So a court is unlikely to say he's got perhaps an equal interest in the home, or in the equity in the home, partly because he's got that pension and she hasn't. So the court is going to take it into account when deciding what to do with this house and the equity that's in it. But it makes sense for everyone to try and retain it at least for a period of time, and to give her the ability to do so. The house is only got £350,000 secured on it. It may be, given time, should be able to get a mortgage to take on his liability. If not, it may be that if she can't afford to take it on and pay him out of his share at an appropriate point, she may have to sell it in order to pay whatever lump sum the court was ordered, I suppose. Or the house can keep it in joint names for a period of time. Credit card.
Or a spouse and a husband is not responsible for
No.
the wife's step of the divorce.
No. Might you give her the money in the bank account though?
If you could evidence that the money on the credit card was used for the family, That's not really cool. She's got this different thing on.
Yeah, but there's no money to pay it off. What you might do is pay it down, because one of the big problems with credit cards is the interest that you pay. If she's got a £10,000 credit card, she's paying a lot of interest. So at least you could use some of that money to pay it down. But you're going to have to take into account in her income that that is a liability that she needs to be able to pay. So it's part of her budget that you can't ignore. Is she going to be able to wait until a child is of secondary school age?
No.
I doubt it on these figures. You can work out though what child maintenance is likely to be paying. Somewhere between 15 and 20%, depending on whether the court finds that Dominic is a child of the family and the extent to which you think a Guernsey court is likely to pay attention to that. And then thinking about what additional income she needs. She's likely to get spousal maintenance, isn't she, for a period of time. And that's largely because despite the length of the marriage, she's got a child. Very difficult. Again, there's no answer to that.
What do you think then?
I would probably give her spousal maintenance for at least 5 years. I would say. Possibly a bit longer, because even at her highest, she's only earning 30,000 a year. But I would give her some maintenance for a period of time. You'd have to look at how the mortgage is going to be paid. Do you think they can afford private education for their children?
That's a luxury that we need.
Yes, and that would be a very difficult discussion to have with her. Because some women put that as a need above their own housing needs. Bizarrely. Okay. So what would, if this lady came to see you, what advice do you think you would
Did you want to apply? You applied for spousal maintenance. You would also apply for child maintenance, and you would have to then apply for a child and family as well as a child and marriage.
not consider it?
Because the house is on a good rate, could you advise for a measure or a Martin order?
You could certainly look at both, just be slightly wary of measure orders for the reasons that the court has picked up on and the reasons that I've given. They don't always work to the benefit of women. But look at the Guernsey cases and the creative way that the court has approached these cases. But yeah, they tend to use chargebacks, don't they? Keeping the house in joint names until certain trigger events appears to be quite popular, and then having a chargeback. At which point, presumably, if the wife can't pay the charge and get the house in her own name, she has to sell it, one assumes. That might be a way forward, which the court seems to have used in the past. You might then divide the equity in a few years' time. How do you think you divide the equity? Let's assume they're jointly paying the mortgage.
This where earning capacity would then come in. If Adam has got a greater earning capacity, and he's going to be able to accumulate savings and.
He might, but then if you're asking for child maintenance and possibly spousal maintenance, and he's paying something towards the mortgage, it's not going to have much left, is he?
No, that's true. That's going to be 20 plus, isn't it?
It'll be 50-50.
I wonder if, in fact, you would say it's 50-50 case later down the line. but in the meantime, part of his taking care of his spouse might be continuing to pay the mortgage for a period of time. Or at least paying spousal maintenance sufficient for her to pay the mortgage.
The 50-50 is normally where there's so much money that.
Well, that's true, but in a sense, how would you justify, is giving her an extra £50,000 going to make a massive difference in her ability to buy somewhere else? You're only looking at £150,000 worth of it. So the only reason you would depart from an equal division is if it's going to make a difference. So I don't think you would be selling the house now and dividing everything else up equally now, because I don't think that would be fair to anyone. You might have an equal division, she might get a bit more. He has got his pension. You know, she might get a bit more to reflect the fact that she may be able to get a deposit on a house flat, perhaps in a few years' time. You might need to know a little bit more about that. But I don't think it would necessarily be wrong to divide it down the middle. I don't think it would be wrong to give her a bit more.
What about if
for a pension provision, perhaps?
Yeah, the 2 children are living with her, then she might need, well, I suppose if she had overnight contact with the same thing.
Yeah, one of the things about housing provision is that although the primary carer tends to have a greater call on housing. So if children are living pretty much full-time with one carer, they are going to get the first call on housing provision. But often a dad will say, well, hang on a minute, these kids are staying with me 2 nights a week. I've got to be able to have a decent home too. So the chances are that if it's affordable, they're going to be looking for fairly equal accommodation or a similar number of bedrooms. Where there's more than enough money to go around, you might say, wife needs the nicer house with the more X, Y, and Z, but they might need the same number of bedrooms if they've got a girl in the boy in particular.
Yeah, and then that impacts maintenance, doesn't it? The more time that they spend with the carer for maintenance.
It does. You don't know much about contact, but as far as you're aware, the children have their home with you don't. You also know that I don't think Dominic's dad is paying anything for him really.
Could you get the court to, or if you've got a consent order before the court about the education, the court to say that it's not feasible for private education?
You're going to have to address it with your client first, aren't you? She's going to have to rethink what her expectations are about going back to work and about private school. And she may well say he could afford it if he wanted to. He never ate very much. I've heard people say that. He was always a frugal person. He could do it. I complained he never spent enough money, so he'll never spend money on himself. He can give it all to us. It's not uncommon.
So what would you say to her about private school? Because we owe it to her.
I would say I don't think it's affordable.
Okay.
I'd be quite almost blunt about it really and say I don't think you can afford it. I don't know where the money is coming from unless you can find a generous grandparent to pay for it. Which happens a lot. But I'd be saying I do not believe that can be afforded, and unless both of you agree that you want to stretch yourselves financially in order to afford it and give up other stuff, I would say I don't think you could put order.
Which might be something that they do agree on, but he's not going to consult us. Yeah.
No, and it's unlikely on these facts he'd agree it, but quite often you get grandparents to step in to pay for private education. For whatever reason. Your main concerns are going to be how's the mortgage going to get paid and how's she going to meet her general expenditure. You see, one figure you could get rid of by paying down credit cards is that credit cards and loans figure of £500, and quite often taking loans out of the equation is really helpful. because credit cards in particular, the interest on them is disproportionately large. And the longer the debt's been sitting there, the higher the interest rate will be, or rather the higher the monthly amount will be, potentially. Yeah, horrible things credit cards and divorce. And perhaps, yeah, some of the maintenance he pays, spouse maintenance he pays, should be paid direct to the credit card people. You could do that. Part of it could be paid to her so that she can discharge the mortgage. And then that leads her to needing to obtain an income of £2,000 a month to meet needs. Which actually, if she goes back to work and with a bit of child maintenance, she should be able to do, shouldn't she? Within a period of time. She's not going to walk into a £30,000 job.
Maybe a 3 or 4 year trajectory.
Yeah.
Which
is why I would have thought that she may need a bit of additional help for the next, 5 years maybe. Not massive amounts of, because she should be looking for work, I'd have thought relatively soon, if Charlie's going to nursery or whatever else it is she's got planned.
£30,000 net after childcare expenses.
Yeah, I mean, I don't know what people earn. I'm basing this on what people earn in Jersey. As a woman working part-time in a trust company is looking at about £70,000. A husband working full-time in a trust company in IT might be looking at about 70 if they've got quite a good job. They're not unusual incomes really, but they don't go very far. Court is quite likely to disregard things like cars as assets, certainly in Jersey, because you need your car, particularly if you've got kids, so they're unlikely to say you've got to sell your car and give part of it to your, not that we can order a sale, but they're unlikely to chop off large amounts of money.
Does that depend on the car?
It does. Some cars are assets. As in, I've got 3 cars and 2 of them are Lamborghinis, then fine. But the car you drive on a day-to-day basis, of course, I'm likely to spend a lot of time worrying about that, because then you need a car if you've got children, it's a normal basic car. So whether it's part of the pot or not is arguable. It's an asset you have to disclose. Well, she's got to be able to service it, which is why you've got that credit card and loans figure. She'll still be left with a loan, and part of her reasonable needs to be able to service that. Definitely, she should be able to service the debt on the car.
Actually, that figure is, assuming the interest is not ridiculous, 2 years and it's all gone. If she's working, then that's extra to meet her
needs, yeah. Right, so, and I think we shall do domestic violence next time.
Thank you, Claire.
Next month it is.
Enjoyed it.
Good.